Yes, we have allowed the application. On one of the arguments made by you, we have held that he is not similarly circumstanced with the other employee. That was your argument also.
Yes, yes.
Yes. The order has been set aside.
Yes.
The respondent authorities are directed to extend the benefit of grade pay of rupees 4200 to the petitioners from the date of their promotion to the post of chargeman within 3 months from the date of communication of this order.
Deeply.
Yes.
Number limit 25.
We have affirmed the judgment of Honorable.
That I am praying my Lord, direction upon the Tahsildar to execute the order. Otherwise, it is very difficult. My Lord.
The direction from the in the impugned order, impugned judgment, that was
Yes, the direction was already there.
No, that direction is already on. Within time frame that is to be implemented. Otherwise, they will not implement the order. I won't get the property for another 10 years.
I'm trying for.
Within 3 months.
3 months. I'm deeply obliged.
Grateful.
Item number 3, payment is 74 of 124.
I am there for the petition. I am filing the paper book. I have served the copy to the others.
We have just received the copy of the paper book. So my lord may have it on the next circuit, my lord, because my lord will take time, man.
Next week, it will be difficult to take up longish matters, right? There are
Take a
already
chance,
lot of matters fixed in the next week.
Let it be
Paper
on,
books are filed
my lord, let it be on Wednesday, my lord.
next end of this month. Paper books are filed. Let it be on your prayer, Mr.
Yes, yes, no difference.
On prayer of
No,
the matter be placed before the next event. Next.
Same, my lord. Item 4 also, my lord, same, my lord. They have just now served the paper book.
Same order.
Let it be, let this matter be in the next week, my lord.
My learned friend, entire first week they sought, I have no difficulty, my lord, but we also need to examine. Paper book has just been served. Mr. Kumar will be very busy next week. So many of his matters are already fixed.
Well. Yes, next week there are a lot of matters fixed. In fact, madam, all your matters are the next weekend.
Item number 5, SLC 125.
Alright, in item number 5, we have filed the CAN applications. For that, we have sent the respondent through speed post, and it has been not served to them. The item is showing Monday room. I don't know that the matter may be fixed on the Wednesday or
Wednesday?
Yes, ma'am.
Since service upon the respondents is not complete, let the matter stand over till 6th August.
We will file service.
Affidavit of service be filed on that agenda.
Item number 6, Committee 29 of 2025.
My lord, in items for 6 and 7, we are filing Bakalatam of today for the respondent. In this matter, this issue, very short issue is involved, my lord. It can be fixed in the next week.
Can you come back tomorrow?
Oh my, next week. Very short issue.
Yes, Mr. Kumar, short one?
But I can be fixed on Thursday as
Thursday, no.
Wednesday, my lord. Because already Tuesday, Wednesday, a lot of matters have been fixed.
That is what even we were thinking. So it's with regard to release of areas, salary,
The period which they have not worked.
Tuesday. Fine. Both the matters, 6 and 7? 6 and 7.
Both matters, we are fine.
Learned counsel for the respondent seeks accommodation. Paragraph, let the matter appear under the same heading on 5th August 2025, Tuesday. 6 and 7, same.
Item 8, Act 71 of 2024 with can 1, can 1, can.
Mr. Lordships. Without the two appeals challenging the orders passed by the learned single judge. Now, there was a can 3 is there, can 2 has been disposed of. Can 3 is there. Lordship will kindly look at can 3 first. My learned friend is there on behalf of the writ petitioner,
The respondent here.
respondent.
My lord, entire appeal be taken up, my lord. Not the can application.
It's also.
They are represented.
They are represented.
For 2 and 3, Mr. Shivaban.
They have filed their affidavit also. Everything is there on.
Yes.
The short point is, what I'll try to place before my lords is that the writ petitioner is a rank outsider. He has challenged construction of my building, etc. He is in no way affected. Now, we did not get copy of the writ petition at the first stage, which is why an order was passed. Consequently, another order was passed. The two orders are dated 14/11/2024 and 18/11/2024. On 18/11, I had come before my lords and the order was modified to some extent. Thereafter, my lord, we have taken the maintainability of the writ petition. We have placed it under challenge. Now, lordship will kindly look at the division bench order. At paragraph 2, I have set it out. It is also there in the.
Yes.
Lordship would be pleased to come to annexure A1, page 11, page 10.
Yes. The issue of maintainability was raised therein, right?
Yes.
Single bench, it was never raised.
No, single bench, we have also raised it.
No,
Anyhow, even otherwise, Lord, it is before your lordships. We have raised the point of maintainability. It has been considered by the honorable division bench, Lord, and the order was passed.
Yes.
Now, my lordship will be pleased to first look at paragraph 5. So the other division bench in a similar matter has already said that writ is not maintainable. Lordship will keep that in mind. Next, Lord, I am coming to the next paragraph, Lord, which is relevant.
Yes, this is your submission made before the division bench.
Yes,
right?
division bench, yes.
Yes.
Now, Lord, a coordinate bench has already held this way, my lord. This is one. The second thing is, my lord, lordship kindly comes to paragraph 12 and 13.
Yes.
Particularly paragraph 13.
Yes.
The respondent numbers 2 and 3, while filing their affidavits in opposition, must and should disclose the copy of the original notification and the decision of the appropriate authority in support thereof, if any, with regard to the document disclosed at page 24 to the said petition, in addition to whatever they will take in the light of the case made out in the writ petition. The respondent number 4, in addition to whatever their stand will take in the made out in, must and should disclose what steps they have taken up. Now, my lord, the affidavit has come, that has been annexed, my lord, as annexure A2, my lord.
Yes.
Now, my lord, the relevant portion would be page 3 of the affidavit, inner page 3 of the affidavit, my lord, paragraph G. That there is no notification as mentioned by the petitioner. However, there is a press release regarding eviction of unauthorized occupation from government land and cautioning to the general public to desist from any illegal act of encroaching of the government land. That through the said press release, the citizens have been urged to report illegal construction or any encroachment in district control room at phone number so and so. Such releases are being published at repeated intervals by cautioning the general public citizen not to resort to illegal act of encroachment upon government land. The instructions have been passed on to the general public through the press release. Now, my lord, my humble submission is that there is no notification relating to, therefore he has no cause of action. He will make a complaint, but he cannot come before a court of law and say there is a specific notification by which I am entitled to come before a writ court and ask for demolition, etc. Particularly because he has made a submission that 24 page, but that is part of the document which was placed, but that your lordship would be pleased to come to. Page 27 of the stay application, Mat 72. Lord. Lordship has got it, Lord? It's a newspaper.
71, I think. Not 72.
Mat 72. Hey, George Chapkin, Mat 72.
This is 71 in time. The stay application.
Kindly comes to page 27, Lord.
Yes, sir.
I'm sorry. This was the document which was the basis of their filing the writ petition. Now, this is not supported by any notification of the government.
Page 22.
27, my lord.
Newspaper.
Yes.
और कॉपी देना और एक कॉपी देना अच्छा अच्छा
Yes.
Now, my lord, this is the specific reason they had shown this document before the appeal court, saying that we have a right. Now, therefore, the appeal court said that whether you have a right or not, let us see whether there is any notification in support of this newspaper publication. There is no such notification. Therefore, my lord, there is no alteration from the situation in the earlier appeal where Mahesh Babu's case, it was dismissed. My lord, that is part of the records, probably in the file. Otherwise, I'll hand over a fresh copy.
It's a part of your stay application.
No, but it should, we had given it by hand, but it is also there in the, in their, affidavit in opposition. My lord. Affidavit in opposition, it will be there. My lord. देखो
Yes, affidavit in opposition.
it should be,
तो फिर से तो जब करने वाले dismiss कर लेंगे ना तो एक construction.
my lord, instead of that, my lord, I'll hand over the document. It is better. It will give me a copy.
Have another copy.
I'm giving. And you know, it is there in the file, but the file has become voluminous.
Yes.
So therefore, my lord, my humble submission is that there is no alteration in the situation as in the order which was passed by another coordinate bench of this honorable court. There is no notification, therefore the writ petition was not maintained. If the writ petition is not maintainable, both the orders passed on the basis of the writ petition, Lord, they are bound to fail, and the writ petition is liable to
It's passed in the writ petition.
writ petition. Lord.
Page 76 of
The first matter?
MAT 71.
Page 76.
76,
Seven.
71.
State. 71.
No, 71 is, no. 71 is stated.
State petition of 71. This is not the final order.
No, the first order, my lord, is at page 51.
The final order, disposing of the writ petition.
No, disposed of.
It is not disposed.
The writ petition is pending.
Yes, the petition is pending. We challenged it on the ground of maintainability before the appeal court. The appeal court passed that order, which I had shown your lordship. And accordingly, Lord, affidavits have been exchanged. And the point of
Did you
maintainability,
challenge the maintainability
No.
for the writ court, the
No.
single bench?
Lord, in the writ court, Lord, we didn't have occasion to come before the writ court at the first stage because we didn't have any. Lord, that order, your lordship will kindly come at page 51.
Which you ought to challenge it before the writ court.
Problem is, Lord, that if it is not maintainable, we didn't get a copy of the order. Page 51, if your lordship kindly sees first,
Yes.
the first order,
52.
51,
51 is the
Let
service.
service be effected.
affidavit of service filed in court indicates that.
That is 52.
My lord, the order dated November 14, 2024.
You were respondent number?
I am the respondent number, I was not represented.
In the writ petition,
Four.
you were 4.
Four.
You refused. That's the endorsement in the. Yes,
Now, my lord, we were not represented then. Subsequently, kindly comes to page 76.
yes.
Lordship has got the order, my lord. Its order is dated November 18.
76.
77. 77.
76 is the certificate of establishment.
Maybe. Which one page is? I'm sorry, my lord.
77.
I'm sorry, my lord. I'm sorry.
Oh, there was a modification
There was
and a
a.
direction for affidavits.
Yes. Now, my lord, we challenged both of them before the appeal court, taking the point of maintainability before the appeal court. The honorable appeal court passed that order, which I showed your lordship, which is, my lord, the order dated, my lord,
21st March.
February 20.
February?
20. Lord, that is part of Can 3. Can 3.
Yes.
Mine. Is that order, where you were here when I appeared on BC. That they said the writ petition will not proceed until they. 803. 803.
Must should disclose the copy of the original on the application, the terms of appropriate court will support this. If you leave it with regard to the, you can disclose the date.
Grant liberty to appear before the single bench and raise this issue.
This was taken care of by a subsequent order passed by the appeal court, because they had expedited the writ petition. Then we came before the appeal court, and that order, my lord, is there in the order sheet.
At page?
Find order sheet, my lord, not there.
The-
Subsequently in the appeal.
Order dated?
It should be
Is it a 9th April order?
9th. I'm grateful. 9th April.
Yeah, why do you say that this issue was taken care of by the appellate forum? I don't find so.
The third page,
Yes.
third paragraph. We have
Yes.
heard the learned advocates appearing for the respective parties and perused the earlier order dated 20th February. it appears that the present appeals have been preferred challenging the interim directions passed by the learned single judge on 14th November and 18th November. My lord has got it now.
Yes.
The appeals would become infructuous in the event the writ petition is heard and disposed of during the pendency of the appeals. In view thereof, this court directs that the writ petition shall not be heard till the present appeals are disposed of. Therefore, my lord, there is a prima facie case that the appeal should be heard first. And my lord, I have raised the point of maintainability which I can take at any stage of the proceeding. It is not that I have to take the proceeding because it's a pure question of law. This is decided, my lord, up to Honorable Supreme Court.
Any stage of the proceeding before the writ court.
But
Not.
because two adverse orders were passed, my sealing of my hotel was done, etc. Therefore, I had come before the appeal court. Now, my lord, if in the appeal court, I can show your lordship that this point is there, that point of maintainability, earlier order passed by a coordinate bench, my lord, would it not be your lordship's pleasure to look into it and pass orders? I am asking myself this question, bro. Very humble submission.
Because your primary issue of submission is that since the writ is not maintainable at all.
Right. So therefore, my lord, you
To
are
the interim orders, right?
the interim orders go.
There is already an interim order sealing your property that
Yes.
is there. The other part of the interim order has been stayed for the time, being,
Yes, yes,
right?
yes.
So I think this needs to be thrashed out. before the
Well,
writ court.
well, only one thing. Would it not be unnecessarily going to the report when already I have shown before my lords that there is no notification? Kindly appreciate, my lord. I bow down to whatever your lordship will say, but I am asking myself this question. That would it not be a futile exercise going before the writ court unnecessarily when your lordship can decide the point?
Cannot be unnecessary, sir, because the writ petition is pending. We are not remanding it back.
My lord,
It's already pending. There was a direction for affidavits and the writ petition will continue to be heard by the.
the other part of the thing, if it is not maintainable, why should there be an interim order which is affecting me adversely? I'm asking myself this question. It has not been totally, it has not been totally, I have not been given the reliefs in the interim stage, no. There were two parts to the order, my lord. One was that the hotel should be sealed
The sealing part and the demolition part.
and the demolition part.
Yes.
Demolition part has been stayed, no doubt, by the appeal court, but not subject to maintainability. Why should, my lord, I'm asking you, I bow down to whatever your lordship will say,
The writ court has recorded an adverse order against you, sir.
which is why I am before the
Your
appeal court.
client. No, with regard to service of notice. There
That
are
will-
certain
my lord,
observations made.
I have, to
So
that
you
I'll give a
cannot
reply.
make this point now that
Lord.
you were not given the opportunity to raise the issue.
My lord, one thing, my lord, that document, if your lordship goes into that part, your lordship will find that it was never served upon me.
Because you refused, could not have.
No, it was not refused, it was not given.
Well, that.
That is the unfortunate part, that is one, that is one. The second part is, my lord, that a writ court passes an order, modifies it. I challenge both the orders. Appeal is entertained, order is modified to some extent. Point whether notification is there or not.
In the appeal, there has not been any further modification.
No. The first time, when it was moved. And in that, my lord, there was a direction for affidavits.
Yes.
Now, if the direction for affidavits is there, with the further this thing that whether there is a notification to this effect, which is the basis of the writ petition, and a document comes which says that there is no such notification, would it not be your lordship's pleasure to consider that aspect of the matter along with the coordinate bench order?
Yes, but this has to be dealt with. Let us hear the.
Lordship.
This will be the other one.
If we take a decision, then it will be infructuous even before it is disposed of. It's pending.
It was not maintainable. So question of infructuous doesn't arise. It was not maintainable.
Yes, let us hear the.
In the first order, my lord, there is a refusal. In the second order, my learned friend appeared. He did not raise any point of maintainability. Let us see that order, my lord. Second order.
The writ court, sir.
Writ court order, November 18. page 76, in my copy, it is page 76. Stay application of MET 71.
November 18, page 77.
Possibility,
Page 70.
pagination is not properly done.
Page 77, yes.
77. My lord, kindly see respondent number.
Yes, yes, I appeared. I said I appeared.
He did not.
I'm not concerned where I have not appeared. I appeared
He
myself.
did not raise that point of maintainability. How you can raise it before the appellate court? This is first point, my lord. My second point is that, Lord should kindly come to page number 24. Stay application.
Yes.
My lord, we'll find the newspaper cutting, my lord. This was published by the government. It's government original newspaper I brought. Kindly see who published the newspaper, my lord. Directorate of IPNT.
Yes.
And they are inviting applications from the
Public,
Complainants.
members of public, yes.
public. Now, in this case, my lord, the appellant suppressed the fact that there is already a demolition order. I will show that also, my lord. For a minute, time may be given, my lord. Kindly come to page 26 thereafter. Page 26, my lord.
Yes.
Order passed on, my lord, kindly see, 17th August 2012. This is demolition order.
This is prior to the writ.
Yes. 2012, 17th August 2012. Lordship, find the date from bottom.
Yes.
Now, my lord, kindly see paragraph 1, 2, 3 from bottom.
Since we are not inclined to entertain the appeal, let the appellant go back to the writ
We
court.
cannot raise the maintainability, my lord, again before the writ court, my lord, because at the first instance you have not raised.
This cannot be,
Yes.
this cannot be.
No, it can be raised at any stage of the proceeding. You are aware.
At the first instance.
We will grant liberty to the appellant to raise the issue of maintainability before the learned trial court. Let the trial court decide all the issues, including the maintainability issue.
My lord, within time frame.
If you
You
feel
will not find the affidavit, he has taken.
you are aware that the Supreme Court has deprecated fixing time frames. By
Where, my lord? At the earliest,
At the earliest, absolutely.
My lord.
Absolutely. Let that be done.
Only one thing, Lord, subject to mileage.
Already there is a demolition.
I have filed an affidavit in opposition to both, all the, this thing. Your Lordship, kindly just once.
In
No,
the
in the appeal court.
Nothing was.
Writ petition I have not filed because I have come up before in the appeal court, Lord. And my Lordship will kindly record my very humble submission, my Lord, that already there is a coordinate bench order which says that writ is not maintained.
No, that
Where
line is not
does
there.
it say that it is not maintained?
That line is not there.
Oh, the other order.
Yes.
Stick to that order.
So, my Lord, your Lordship is bound.
It's your submission.
Yes, yes, my submission.
Then? It's not-
Your Lordship will take care of that.
I'll record, we'll record that.
Now, my Lordship, kindly once come to the affidavit in opposition.
Demolition order, my lord, it was passed on 24th February.
It doesn't help because after that, I'm showing that. I'm showing that.
You have never checked.
Oh, ho. Your Lordship kindly comes to,
Outside. Hotels. That is the reason.
that is the submission. That is not correct, my Lord.
That is not correct. It's a demolition order. I got it. Under that, yeah.
Where is our, this thing? Affidavit in opposition to the affidavit in reply. Just give me the affidavit in reply.
Go ahead.
My Lord, I bow down to your Lordship. Your Lordship will take care of it and send me back.
I'll
Since your Lordship is, my Lord, with great respect, my Lord, probably I could maintain the appeal and the appeal could have been disposed of by my lords. I still believe that, my Lord.
We don't feel so let us.
As your
Our
Lordship,
way.
your Lordship's judicial conscience is most important. But kindly takes care of my point of maintainability so that it can be raised before the writ court, and Lordship will grant me some time to file the affidavit in opposition to the writ petition.
It's the,
And keeping the division bench order earlier passed.
why two appeals against both
Two orders,
orders?
two orders.
Against two orders. The appeals are directed against orders passed by the learned single bench on November 14, 2024 in WPA 625, on November 14, 2024 and November 18, 2024 in WPA 625 of 2024. By the first order, comma, the learned court directed eviction of the fourth respondent slash appellant from the land in question and demolition of the unauthorized construction of a hotel raised therein. By the second order, comma, the earlier order was modified to the extent that the authority was directed to seal the the hotel remaining sealed would remain, but the demolition order was stayed for the time being, stayed till disposal of the writ petition. Stop, the writ petition is still pending. Paragraph, learned counsel for the appellant submits that he was not able to appear before the learned writ court initially, for which he was not able to raise the maintainability issue before the said learned court. Placing reliance on an order passed by a coordinate bench of this court in MA 5 of 2023 on March 21, 2023, comma, learned counsel submits that since the petitioner in the writ petition is in no way connected to the property in question and there is no infringement of his legal rights in the issue, comma, he has no locus standi to file the writ petition or challenge the allegedly unauthorized construction slash occupation of the appellant. Paragraph. Per contra, comma, learned counsel for the respondents. Mr. Shivpalan is still not there. Yes, we were looking for you. Respondent submits that that demolition order has already been passed by the authority on 17th August 2012 pursuant to a newspaper publication by the government directing
For the respondent number.
removal of unauthorized occupation on government land and requesting the citizens slash people at large to report such encroachment before the authority. Paragraph.
Lord, may I just make one? In my affidavit, I have said that there is a one-time relaxation document is there. That is part of the thing that your lordship will kindly record. One-time relaxation, Lord, let me tell your lordship, Lord, it will be in the affidavit in reply to the respondent number.
Unauthorized transaction.
Three.
Respondent
Respondent number 2 and 3.
Even our Honorable High Court, Calcutta, Chief Justice passed on order. Public interest litigation is maintained.
Those are in different cases. Here it is a different case. Lord, lordship kindly takes up my affidavit in reply of the appellant to the affidavit in opposition on behalf of the
Yes.
respondent number 2 and 3.
Yes.
Now, Lord, there I have shown, Lord. I have annexed a document, my lord, where there is a one-time relaxation. The lordship kindly comes to that document.
Annexure A5.
Annexure A. Annexure A5. That is page, my lord, would be,
This was your submission before this court, that this has, your construction has been regularized.
no, not, it has not been regularized. This document is there, the matters is pending. This I have annexed to my affidavit in opposition, reply, my lord. And here, my lord, particularly resolution number. Lordship, give me a minute, my lord, I'm showing you. Lordship.
That is not deciding the appeal.
No, because your lordship will be recording my submissions.
Court decide everything.
Yes, it will definitely. But, inner page 3, my lord, of that document,
Yes.
agenda number 6,
So the
item number 6, my lord.
What is the resolution of the municipal council?
Will you allow me to submit or you will say?
6 is page 10, inner page 2.
Inner page 3, my lord, inner page 3, agenda number, item number 6.
6 is in page 2, inner page 2.
Oh, I'm sorry then. My lord, lordship kindly see.
Thereafter, the council approved the recommendations.
Was
That is,
That,
all those matters are still pending before the council.
brought down by the governor.
My lord, I cannot submit if my learned friend continuously
let us not
disturbs me.
do this because you are not dealing with the.
No,
the
because
complainants.
your lordship is recording that there is a demolition order. If that recording is there, then my lord, my humble submission is then that although there is a demolition order,
Submission.
no,
We have not
my
made
learned
any
friend submission.
Submission, we have not made any
And my
observation.
lord, my submission, kindly record that also, that there is this order, this document had come after the demolition order. This document had, my lord, that is recorded in my affidavit in opposition. Lordship will kindly just look at it once more.
What is the
I'm
document?
sorry to
about?
trouble your lordship.
What is the document about? We do not
My lord,
understand.
it's a document which says,
Approve the recommendations made by the subcommittee of financial tax.
no, not that one, my lord, not that one. My lord, my lord, 10, 11, 12, my lord, your lordship will see. The assistant architect said 360 notices demolition orders have been issued upon the persons whose buildings were constructed in violation of the building bylaw since 1991. As directed by the chairperson of the council, a survey is being conducted to identify unauthorized constructions. And 142 such cases as have been identified. So far, notices for these cases are being prepared. As per provisions contained, the entire building list comes under a non-compoundable violation. The last of all, lordship kindly comes to next page, lord. Resolution number 92.
council resolves to regularize the cases.
I'm grateful.
That is,
I'm grateful.
that was with respect to sanction building plan. Any
As one time say,
Any deviation. Unauthorized
my
construction.
case is, my lord,
Allegation
kindly,
against you is unauthorized construction.
but lord, all these matters are pending, no decision has been taken. Kindly records.
We record this, it will go against you, sir, because we will record that this is only in respect of buildings which are in deviation or in violation of the bylaws.
Lord, unless your lordships.
Allegation against your building is, it's a completely unauthorized construction.
It is that allegation that is not, because there are documents to say.
Write it out before the trial, before the writ court, not
Yeah.
here. We will not go into merits at all. Please let us
Your
know
lordship.
if you find it. Last week. Paragraph. We have considered the material on record. The primary grievance of the appellant is that the writ petition is not maintainable and therefore the orders impugned could not have been passed by the learned single bench.
I'm grateful.
It appears that the appellant appeared before the learned single bench on
18.
2024, and yet did not choose to raise the issue of maintainability of the writ petition. However, since the appellant seeks to raise such issue and further submits that the orders impugned are bad in law, since the writ petition is not maintainable at all, we are of the view that the appellant ought to be granted liberty to raise the issue of maintainability of the writ petition before the learned single bench when the matter is taken up by the said learned bench.
Lordship will give me an opportunity to file an affidavit. Lord.
Yes. The paragraph accordingly, the applications being both the numbers, strike this one later. Accordingly, the appellant is granted liberty to raise the issue of maintainability of the writ petition before the
Along with other
Learned-
points, Lord. Along with other points, because I'll be raising the point.
other issues on merits,
Lordship.
along with other issues on merits,
All parties.
before the learned single bench. Your affidavits are complete there otherwise.
No, yes.
No.
Your
I'm the.
No, he is writ petition.
is the writ petition and is further and also to use affidavit in opposition therein, if required. Stop.
To which they will file an affidavit in reply.
It's their choice.
They have to
Support
file the
analysis.
affidavit in time, my lord, otherwise it will be shared.
Such application / affidavit be filed by the appellant before the learned writ court, learned single bench within
3 weeks, Lord.
from date,
Yes,
within 3 weeks from date.
1 week for filing reply.
The
Not reply, opposition.
petitioner therein shall be at liberty to use a reply to the said application / affidavit, if required, within a week from filing of the same.
My lord, the other authorities also are there. They have to also file. No, not in the writ court. Writ court.
Writ court. The writ petitioner / other respondents. Writ petitioner / other respondents. Paragraph, the applications being both the numbers are accordingly disposed of. Paragraph, it is made clear that this court has not gone into the merits of the case and the learned single bench shall deal with the entire matter on the issues of maintainability as well as merits in accordance with law.
Lordship. I felt that since your lordship is demanding, so let me have the affidavit in opposition.
There will be a full-fledged hearing.
This is the of the Honorable Supreme Court also, I know that, Lord. But then I felt that
The writ is still pending. If it would have been disposed of, we could have passed a different order.
I understand. I appreciate it. Not only that, there is a loss of forum also.
Yes.
That happens. There is a
absolutely.
loss of forum because either way, if it goes,
See,
the
on the
only,
Supreme Court, yes,
it becomes really difficult.
I understand.
I'm grateful.
Next. Yes, 10.
With Karmakar represents the state. However, the victim girl was also served with the notice because there is a mandatory requirement that she should. So previously the matter was actually heard and thereafter she came up with the application that she's ready to marry him and the marriage was also performed. And thereafter,
That doesn't absolve the.
that will not,
of the offense, yes.
then the matter was adjourned sine die. Meanwhile, again, she appeared through a counsel stating that now he started to abuse her like anything and he has set fire in his own house. There was something wrong with the accused person. So then she came with the prayer to cancel his bail. And meanwhile, he was already arrested for setting fire of the house. So now today, victim,
A report was called for from the member secretary, SLS.
Because new council has to be appointed.
Yes, yes. For the appellant.
For the appellant.
Has any report come? Was this sent to the member secretary at all? Yes.
sir, पूछ रहे हैं.
Was this sent to the member secretary? Please find. I think it was not sent,
July 29.
not previously after this order. The report was called for. You see this one? It was not sent. Isn't it? Please send it. This appointment to happen.
First.
This report.
Let
Let it appear on the 7th. I think this was not communicated to the
Right.
secretary.
Yes, sir. That
Please
can.
communicate the order immediately. No report is received from the learned member secretary. SLS. Paragraph. Let the matter appear under the same heading on 7th.
But she has received the.
You are representing her.
Earlier, Ms. Shikha Mandal has appeared.
So who will be appearing now? Because she needs to be represented.
Yes.
Please find out by the next date.
No.
We can at least regularize the issue before
Right here.
the matter is
She
taken
was
up. for hearing.
present in the courtroom, so I made her to go out because
Yes, absolutely.
she's, huh.
We require to see present in the court. If she requires, we can advocate.
No,
From
no.
SLS.
It's represented, right?
She was earlier represented by earlier counsel.
If she is not represented now, and we can arrange for an advocate from the SLSA to be represented.
If she desires so, ask her. Ask her.
Yes,
Please
I
ask her.
agree. You are appearing now. We are fixing this matter on 7th, right? So please find out in the meantime whether you are representing the victim girl. Otherwise, we'll take necessary steps for appointment. Let the report come. Let the appellant has to be represented. 7th. Report please submitted on the agenda. Next.
But this is an appeal, the section 37 of the Arbitration Act. We have filed an application for a stay as well as along with an appeal. Now the stay, they have been filed as affidavit opposition. A perused, my lord, they have, rather they have want that the appeal should be decided on merits. Ensure that is what then applied, the opposition they have filed. No, my lord,
This is opposition against the stay application,
stay,
not the appeal.
not against the appeal.
So let
We
both
fi-
be taken up together. Why don't you file a comprehensive opposition? Yes, yes, there's no order. Fine.
And let them deposit the money. Yes.
Have you deposited the arbitral amount?
No, my lord, it is not.
Seventeen, 15 September 2017.
You have used your affidavit in reply?
No, my lord, I checked it, my lord, as I served. It is only that extent only they have made it in reply, my lord. They are not denied the other aspect. They only contention of the appeal should be decided on it. That was the only. But with regard to that, it has to.
Yes.
My lord, I need to submit that.
What is the arbitral amount? The award?
My lord, it is. Is in the award, my lord.
Arbitration Act.
Arbitration constitution.
Sorry, my lord, it is.
Yes. Yes.
There is no complete calculation. The last page of the award. The case is pending.
No, four.
They have committed that they will be depositing the money. But they have not deposited.
That so far as that I am not contesting, not because we filed an appeal, this court has. This court
They're
has.
submitted before the lower court, right? The appellate forum, yes, the first appellate court.
Here they have submitted. That they will be depositing the money.
Is it recorded?
It is before item.
But I don't, let them produce, but so far as I have instruction, it is not there, not that.
Okay, will you, can you show us the order, please?
Everyone have right now.
But my lord, what I suggest, subject to my lord's kind acceptance, as my lord is saying, it is a, under order 43, it is like a money agreement. What is there in the law that I cannot interpret? Subject to, as my lord says, if my lord is passing an order, let the award be stayed, subject to deposit of this required amount, within certain time limit may be granted, my lord, and in the meantime, paperwork will be ready, the appeal can be disposed of. The other side has.
We'll fix it next week. Please show us the order that they've undertaken to deposit. Fifth, very good. By consent of the parties, let the matter appear under the same heading on fifth. 5th August. Yes.
My lord, this matter, my lord, I had argued, my lord, on the last occasion. This is that case, my lord, where the order of dismissal, my lord, has been passed by the appointing authority, that is the Director General of Police. And my lord, their contention is that under the police manual, the Inspector General of Police is the authority, and therefore the Inspector General of Police had to act as the disciplinary authority. But our contention was that under Article 311 of the Constitution, disciplinary action, no authority subordinate to the appointing authority can act as the disciplinary authority. And therefore, in these circumstances, since the actual appointing authority was the Director General of Police, only he could have acted as a disciplinary authority and not the Inspector General of Police, because the Inspector General of Police is subordinate to the Director General of Police, and the police manual cannot be treated as superior to the Constitution. In this connection, my lord, I would like to, in fact, Mr. De Cruz was just going to start his submissions. I wanted to place a judgment, my lord, of the Jharkhand High Court, my lord, which is.
Let me submit first.
No, I am the app. So therefore, I was making submissions, so I'll just complete my submissions. Then Mr. De Cruz can address both.
Petitioner should start.
No, yeah, I had placed this judgment, my lord. This is a judgment of the Jharkhand High Court. It only has persuasive value. But the reason why I'm placing this is because this peculiar circumstance which has arisen in this case had also arisen before the Jharkhand High Court. If my lord sees this decision, 2015 SCC Online Jharkhand 90. This is before a learned single judge. Now, if my lord sees page number 3, point number C, the third ground of the learned counsel for the petitioner is that, now in this case, it was the reverse. So if my lord will see, is that the impugned order is violative of Article 311(1) of the Constitution, which mandates that no person shall be dismissed by a person holding the post inferior to the post by which such person had been appointed. Though the superintendent of police is the appointing authority in terms of police manual, but the law has made distinction of appointing authority and person who is actually appointed. The appointing authority, if inferior to the rank of a person who is actually appointed, then the disciplinary authority shall be the person who is actually appointed and not the appointing authority by virtue of the rule. In the instant case, the appointment of the petition has been made by the Deputy Inspector General of Police, and the impugned order of termination dismissal has been passed by the Superintendent of Police. So in this case, the reverse had happened. Now kindly see the decision, the finding, and on the next page, this was the submission. Now kindly see on the next page, paragraph 7. Paragraph 7, subparagraph Roman 1. Admittedly, the petitioner was appointed by the Deputy Director General of Police, Jharkhand. An impugned order of discharge dismissal from service has been passed by the Superintendent of Police, Chhatra. Article 311(1) of the Constitution mandates that no person shall be dismissed by an authority subordinate to that by which he was appointed. Since the order of dismissal has been passed by the Superintendent of Police, who is admittedly subordinate to the appointing authority, that is Deputy Director General of Police, therefore the impugned order violates the mandate of Article 311(1) of the Constitution, as has been decided by the decisions referred to herein above. So on that ground, my lord, the impugned order was set aside. Now, the point, my lord, which I am urging is that today, my lord, admittedly at page 50 of the affidavit in opposition, the appointment order has been issued by the Director General of Police. And by virtue of that, the Director General of Police has acted as a disciplinary authority and the Lieutenant Governor has acted as the appellate authority. Now, they are taking a plea that the Director General of Police at the relevant point of time was not the appointing authority or the disciplinary authority in terms of the police manual. But what is the sequitur to that? The sequitur would be that according to them, the Inspector General of Police would have to act as a disciplinary authority. And the Director General would then act as the appellate authority. But if the Inspector General acts as the disciplinary authority, then it is violative of Article 311, because admittedly the Director General of Police has issued the appointment letter. Now, secondly, today, my lord, the police manual has been amended. And post-amendment, the situation is that the Director General is only the disciplinary authority. So today, my lord, this is an argument in futility according to my humble submission. Because if today this argument was upheld, again, the matter would go to the Director General of Police only if, for instance, this was to take place today. But fact of the matter is, my lord, even if it was to take place in terms of the police manual at that point of time, if what they are inviting the court to do is to hold that the Inspector General of Police will act as a disciplinary authority. But that would be, with the greatest respect, be violative of Article 311, because the appointment order has been issued by the Director General of Police. This is the only point that they have urged, my lord. So therefore, in my humble submission, this is my argument. Yes, yes, ma'am, absolutely.
My lord, I am the petitioner.
Yes.
The case is concluded by the opposite party.
No, he
Now,
was giving
my
a judgment
lord,
which you can go through, it will help you.
No, this is not applicable in my case. This is not applicable.
Good.
My lord, what happened in this case, OA was dismissed by the petitioner herein was dismissed from service after conducting an inquiry in accordance with the police manual. And he was dismissed. And in the dismissal order itself, it is mentioned that he has to appeal before the appellate authority, who is the Lieutenant Governor. So in terms of the rule, he has to submit his appeal only to the person who has passed the penalty order. And it will be forwarded to the appellate authority by the person who has dismissed him or penalty was imposed. He made the application, appeal through proper channels, and ultimately the Lieutenant Governor, acting as appellate authority, upheld the order of dismissal. This is the case. This was challenged before the
honorable tribunal. Tribunal upheld the penalty and finally said that there is no legal infirmity in the orders passed by the disciplinary authority as well as appellate authority. This is the final order. After getting this order, I made a review application because the finding is actually not correct. The legal infirmity was there. The legal infirmity is in terms of their service conditions are governed by Andaman and Nicobar Police Manual, 1963. So now, as per the manual, there is a provision of initiating the disciplinary proceeding, and the authority is delegated to Superintendent of Police as per section 9.3b. Now, in this case, the charge memorandum was issued by the Director General of Police, which is contrary to the provisions of Police Manual. Second is, Police Manual says, my disciplinary authority, who is delegated with the powers of imposing penalty, is Inspector General of Police. But whereas in this case, the punishment or penalty was imposed by again Director General of Police, which is not the authority who has been delegated with the powers. Now, in the Police Manual, it is mentioned that my appellate authority is President of India. But in this case, the appellate order was passed by Lieutenant Governor. So these are the three major important lacunas which has happened. Now I'll just show the rules. Page number 373 of my writ petition. Actually, before that, I would like to make one submission that when the review was dismissed, I filed a review citing all this legal infirmity. Review was dismissed, but in review this cannot be entertained. So then I filed a WPCT challenging the review order only, saying that the matter may be remanded back to tribunal and tribunal may rehear the matter based on these points. But the coordinate bench has passed on order, which is at page number 405.
Second volume, please.
Page 405, my lord.
Yes.
This is the order passed on 20th March 2025.
Yes.
My lord, I was given liberty to challenge the parent order. I challenged the parent order in this writ petition, and the writ petition was taken up at the time of admission. One order was passed. My lord, first order.
July 15 or?
Yes, my lord. That is Justice Chakrabarti.
April 8. Hit for first weekend. Which code was?
1 minute, my lord. It is April 8th. April 8th order.
Yes.
This was the first order.
Yes.
My lord, thereafter, this matter was heard on 10th of July 2025. It was heard fully, but no order could be passed because the council, penal council who appeared, he mentioned that there is another notification showing the authority upon the DGP. And court passed an order on 10th of July 2025. It was time was given next day to bring it. But on the next day, nothing could be produced. And the court on 11th of July again asked them to produce here on the first day of this circuit. Next day. Relevant notification to produce the relevant notification.
Yes.
My lord, thereafter, the Learned Council on the first day, he said that there is no other notification exist in this contest. This exercise was done by the coordinate bench only because in the affidavit in opposition, this is mentioned that there is the post of Inspector General of Police is upgraded to Director General of Police. But in my reply, I have said there is no such notification, and this is a misleading statement. So, to clear this, the court has carried out this exercise. And now, the submission made by them in the affidavit in opposition is proved to be wrong because there is no notification. They have admitted this. So now coming to my case, my lords. Page number 373.
P73.
373, my lord. This is the Gazette notification. And this is in suppression of notification of Government of India, Home Department, such and such. It is hereby notified that the rules made under Section 7 and 12 of the Police Act 1861 by and under the authority of Government of India. This Government of India means the authority is central government only of India and published in the Andaman and Nicobar Police Manual 1963 and shall come into force with effect from 1st June 1963. This is the Gazette notification, and this manual is published under section 7 and 12 of Police Act 1861. My lord, next page is the Police Act 1861. And this particular section 7 is at page 376, my lord.
Yes.
This is appointment, dismissal, etc. of inferior officers, subject to the provision of Article 311 of the Constitution and such rules as the government may from time to time make under the Act, the Inspector General. Now here, I want to harp on this. The Inspector General, Deputy Inspector General, Assistant Inspector General, and District Superintendent of Police may at any time dismiss, suspend, or reduce any police officer of the subordinate. Now, these are 4 grades of officers. Only 4 grades of officer has authority to do anything against any subordinate officers. These are the 4 grades of officer. This I want to harp on. Whom they shall think remiss or negligent in discharge of his duty or unfit for that seat. Now, my lord, this dismiss, suspend, reduce any police officer of subordinate rank. It is applicable only in the case when they shall think remiss or negligent in discharge of his duty or unfit for the same. So that means this anything if they do during discharging their official duty, this dismiss, suspend, and reduce can be imposed. So, part of official duty. This is my contention, my lord. And thereafter, and this is major penalty. And thereafter it says, or may award any of the following punishment to police officer of subordinate rank who shall discharge his duty in a careless or negligent manner, or who by any act of his own shall render himself unfit for discharge of thereof, namely, these are the minor penalty. These are the minor penalties. And now, so my case is actually the charge is second marriage. This is my charge. And this is an act of his own that I want to harp upon. And the Police Act says only minor penalty can be imposed. And comments. Bottom of this page, comments.
You're really not on the penalty part. You're on the authority who has
No, I am
initiated the proceeding and
yes, statutory provisions, violation of statutory
Yes.
provisions. I am on that only. Appointment, comments below that. Appointment, dismissal, etc. of any police officer of the subordinate rank, such as inspector, sub-inspector, assistant sub-inspector, and constable, etc., are governed by the rules made under Article 311 of the Constitution. Now, my lord, this is subject to the provision of 311 and rules made under 311. Now, rules are applicable in my case. It is very clear from the Act itself, and rules are already made as Andaman and Nicobar Police Manual 1963, my lord. So now coming to the rules.
rules have to be in consonance with Article
Yes,
311, right?
311 and most importantly, Police Act. It cannot be inconsistent with Police Act at all. It should be in consonance with that. Chapter 9. Chapter 9, 379. 379 of my writ petition.
Yes.
the following penalties may be imposed. These are 1 to 11,
Necessary, please come to the relevant part.
1 to 11.
We are not on the penalty.
Yes, and below the penalty, after 12, serial number 12, the table at appendix 9.1 shows the authority by whom and extent of which the above penalties may be awarded to police officer of various ranks. So now we are coming to 9.1 appendix data. It is at page number 384, madam. 384. Now there are 3 columns: inspector, sub-inspector, head constable. Head constable is the last. So now below sub-inspector, I am sub-inspector. So below sub-inspector, I was removed from service. So removal is at serial number 2. Serial number 2. Got it, my love?
Yes.
And below sub-inspector, it shows IG is my disciplinary authority and President of India is my appellate authority.
Yes.
My lord, and section 9.3B is at 381, page number 381. Rule 9.3B. 9.3B, 381. The superintendent of police shall frame definite charges on the basis of allegation on which the inquiry is proposed to be held. So now, as per rule, superintendent of police is the authority to initiate the proceeding, and penalty can be imposed by IGP, and appellate authority in my case is President of India, my lord. This was a I could able to show. And now appointing authority, who's my appointing authority? That is also provided in the rule itself. Page number 47.
Yes.
47, rule 2.2.
Yes.
Appointment to the rank of upper subordinates are made by Inspector General of Police. So I am covered under this. So my appointing authority as per the rule is, and in the Police Act also it is given, it will be governed by the rules. So my appointing authority is this, Inspector General of Police only. So now I am coming to the documents whereby this inquiry was initiated. Charge memorandum is at page number 48.
Yeah, these are by the Director General, right?
Hello?
These are by the Director General.
Yes, I'm showing the documents only. Just I'm not going into the merits of the case, just showing the document. 48 signed by Director General. And then the penalty is at page number 59, the operating part. Operative part.
Yes.
59. My lord, this is also Director General of Police. Now, in this order, kindly see this last paragraph. If aggrieved by this order, may make an appeal to appellate authority, Honorable Lieutenant Governor, whereas the rule says it is President of India. Now, appellate order is at page number 68. This is Lieutenant Governor, Lieutenant Governor, 68. Now that appeal rule is at page number 145.
Yes.
First line, 9.2. Every appeal shall be submitted to the authority who made the order appealed against. So the appeal should be filed to the person or to the officer who has, so the officer concerned should forward my case to the appellate authority. So this is the fact of the case. And this judgment, why it is not applicable in my case, is there are Article 311(1) and 11(2). 11(1) says no person should be removed or dismissed from service uh, by not below the rank of appointing authority. This is one says. But 2 says about fair trial. Fair procedure should be followed in the inquiry, and then only the officer can be removed. I am harping upon 311(2). When the rules are there, when the rules are notified, they have to be followed strictly, and no other way it should be. The person cannot be dismissed from service in no other way. And in this regard, I have already placed 3 judgments on record. So one judgment is
This is the judgments.
judgments. First one I want to show Superintendent of Police, Manipur versus R.K. Kamal. Okay. Manipur नहीं है, वो क्या दिया था? ये लो। रुको, वो मत। My lord, this is Supreme Court judgment. In this, it is clarified that no administrative order can supersede the manual and rule position, and any amendment should be in accordance with the provisions of section 7 and 12. This is the outcome of this. Now, my lord, another judgment was State of Tamil Nadu, the Pramod Kumar judgment. It is much celebrated judgment. Pramod Kumar, State of Tamil Nadu. Para 23.
23?
Para 23.
Yes. Yes, this is settled.
It is settled law, and now there was a confusion between this 311(1) and 2. In many high courts were considering this as instead of 2, they were giving judgments. So that was clarified recently by the Honorable Supreme Court in recent judgment on March 28, 2025.
Do you have the citations, Mr. Chakraborty?
No.
This is 2025 INSC 412. So now in this, it has been clarified that if there is a rule, then rule must be followed. B.V. Gopinath and Pramod Kumar was distinguished, and that is still a good law because they are based on rules. But in this case, they have distinguished that and said that in this case, that since there is no in the rule there is no particular officer is designated, so that will not be applicable in this case. I have just marked the paragraphs there.
Yes.
So that issue was settled here. That 311 1 and 2. That confusion between that. So this is my case, my lord, and the charge sheet, penalty order, and the appellate order must be satisfied with all consequential benefits. That is my humble prayer.
Yes, Mr. Chairman. Not
My
only.
lord, firstly, my lord, if just my lord may note that the affidavit in opposition at page 10, my lord, annexure A1. Affidavit in opposition, annexure A1, my lord,
Affidavit in opposition.
in this proceedings, my lord.
Yes.
Annexure A1, affidavit in opposition, page 10, my lord, is the order of appointment. And my lord will see, my lord, that the order of appointment is issued at page 13 by the Director General of Police. Now, secondly, my lord, so therefore, my lord, admittedly, the appointing authority is the Director General of Police. None of the judgments cited by my learned friend are on this issue, that whether appointing authority is person X, whether a person Y can be disciplinary authority in violation of Article 311(1). 311(2) deals with violation of natural justice. He has not said that there is a violation of natural justice. All procedure has been followed. And my lord, not a single submission, my lord, has been made on the merits of the matter. Kindly see, my lord, the order passed by the Central Administrative Tribunal, which is at page 342. Review petition, this additional ground was taken. Review court said that because the CAT said that it's a new, this point was available to you, so you cannot take it in the review. The High Court affirmed, the Honorable High Court affirmed the CAT's order and said that if you challenge the main order, you are at liberty to raise this point. But the Honorable High Court has not given any sanction to the point or to say that this point is required to be accepted in any manner. Now, kindly see, my lord, where 342, my lord, which is it's a detailed order, my lord, passed by the Central Administrative Tribunal.
Yes.
My lord, I'm just coming to the order in a moment. And what was argued, my lord, was very specific, my lord. They only argued the merits of the case before the Central Administrative Tribunal. Nothing on the competency of the authority or anything like that. It's a long order, my lord. And if my lord comes to page 342 itself, kindly see the facts of the case. My lord may come to page 345, the submissions of the applicant. The learned counsel, Mr. Kabir and Mr. A. Prasad, appears for the applicant and mainly submitted as under. The applicant has become victim of social circumstances. Applicant has been treated in unequal manner by the respondents, since other identically persons situated have not been penalized. In this regard, applicant learned counsel has argued the main reason behind this imposition of major penalty on the allegation that he had contracted a second marriage during subsistence of an earlier marriage. It is stated that on the identical grounds of second marriage, another officer similarly situated, being one Sub-Inspector Ramakrishna, was also suspended, subsequently reinstated, though the said Ramakrishna was also facing criminal proceedings in connection with torture of his wife. Ultimately, she committed suicide. However, no action has been taken against him, whereas in the case of the applicant, disciplinary proceedings were instituted and which culminated in major penalty of dismissal. Further, he just stated that second marriage of Ramakrishna and its consequences had brought disrepute to the police force, yet he was back in service, and all cases against him appeared to be simply covered up after suicide of his wife. According to learned counsel, different standards are being adopted for different persons, which violates the applicant's right to equal treatment. Thus, order of dismissal passed against applicant is in violation of equal treatment. Learned counsel would argue that factual aspect in regard to the marriage of the applicant with one Shabana Bibi has not been considered properly by the inquiry officer, disciplinary authority, as well as appellate authority. It is stated that he married Shabana Bibi on 2nd January 2011. Thereafter, talaq was given to her on 9th August 2011. However, she had conceived the child. Applicant remarried her on 30th September 2013. Thereafter, applicant married another woman, that is Razia Begum, on 1st November 2019. Further, it is stated that despite the fact
these are on merits, Mr. Chakraborty.
Yes, so I am only submitting, my lord, that
Because
this
that was
only point that was argued before the CAT was on the merits of the matter. And my lord, this issue has attained finality since the decision of Chief Justice Iqbal Chagla in 1950s, my lords, of the Bombay High Court. which has been affirmed by Supreme Court several times, including recently, that my lord, it is within the competence of the service authority, my lord, to have a requirement that to contract a second marriage, even if during the subsistence of the first marriage, even if it is in accordance with your personal laws, you have to take the prior, you have to take the prior permission of the disciplinary authority. So this
That's
decision,
not merit, Mr. Chakraborty. We are
that
not-
is the only point. This is the only point. Yes, I agree, my lord. So, my lord, the only point that was argued was this. And now, my lord, so far as the present proceedings are concerned, my lord, admittedly, my lord, the appointing authority is the Director General of Police, and as per Article 311(1), the disciplinary authority has to be a person who is not subordinate to the appointing authority, and the Director General of Police is the highest functioning police official in the islands. So, my lord, in fact, the rules of natural justice have been today, if the disciplinary proceedings was carried out by a subordinate authority, that would be in violation of the rules of natural justice and fairness. He has been
The appellate authority is the President of India.
appellate authority under appellate authority would be the President of India if the Inspector General, that rule was followed. But in this case, my lord, because the Director General of Police was the disciplinary authority, the appellate authority of the Director General of Police under the CCS rules, etc., is the Lieutenant Governor. So, which is why, my lord, here, and in any case, my lord, the petitioner has submitted to the authority. He filed the appeal before the appellate, before the Lieutenant Governor. Now, after so much of water has flown to take this new point that, but he has himself submitted to the jurisdiction of the Lieutenant Governor. So, the DGP, Director General of Police, was not provided as an authority under the police manual, which at the relevant point of time. But because of the constitutional requirement, my lord, he acted as a disciplinary authority, and the appeal went to his appellate authority, which is the Lieutenant Governor. It was up to them, my lord. They could have not submitted to the Lieutenant Governor and said that we'll go to the President. They appeared before the Lieutenant Governor, submitted to his jurisdiction, and now they are raising this point. My lord, this point, my lord, could have been sustained, my lord, if it was done in dereliction or in violation of the constitutional mandate, or if the constitutional mandate was not violated and still the police manual was violated. But, my lord, this is a case where, my lord, the police manual is subservient to the constitution. So, my lord, the authorities had no choice but to act in this manner, because otherwise, my lord, the constitutional norm would be violated. And, my lord, secondly, my lord, this is purely a matter of procedure, my lord. There is no substantive right, my lord. So, if he has nothing to say on the merits of the matter, my lord, or purely on this point, my lord, in my humble submission, this doesn't give rise to any substantive right, because it's not as if an officer subordinate to him has acted as a disciplinary authority. The highest police officer has acted as not an officer subordinate to the. So, if, for example, an officer subordinate to the Inspector General of Police had acted as his disciplinary authority, then it is understandable that there is some malafide or violation of natural justice. But as a matter of fact, the person who has acted as disciplinary authority is superior to the Inspector General of Police. So, therefore, my lord, there is no substantive right which is violated. And as I submitted, my lord, my main submission is that this is in accordance with the constitutional norm, and the police manual cannot override the constitution, my lord. That is my submission.
My lord, in addition to Mr. Chakraborty's submission, only one submission I will make, that the petitioner himself admit that the appointing authority should be the Inspector General of Police. But in his case, as Mr. Chakraborty has submitted already, that in his case, the appointing authority was Director General of Police. So if his submission would be accepted, then my lord, all the appointments made on 31st May 2014 will go.
That is not
all the 50-60 officers will be suspended or removed
taking
if this will be accepted, my lord.
another direction.
We'll reserve this.
Grateful.
I want to make one submission. What the learned counsel has said. Learned counsel is saying that there is no discrimination, there is no harshness, there is no biasness in this case. That is totally incorrect, because now they themselves know that it is a private affair. It is not
We
part.
are not issue at all, sir.
Okay. No, he, my lord, were allowing to. Oh, my lord.
Pardon, concluded judgment reserved. Please send it to my attention.
I'm grateful, my lord.
Next.
Most grateful.
But I appear on behalf of the respondent, Mr. Chakraborty must be.
My lord, this, my lord, matter, my lord, concerns the question, my lord, where whether a decision, my lord, setting a timeline, my lord, is enforceable, or rather is binding, or principle of res judicata would apply, where that particular authority was not party or was not appearing before the court where this timeline was set. Now, my lord, this matter has a long and checkered history, my lord. Since Mr. Shamanto has come all the way, my lord, then I will make my submissions, my lord. It will take some time, my lord. Subject to, because Mr. Shamanto's convenience. Since he has come, my lord, then I have to, in deference to that, if my lord want to hear the matter, then I can argue, my lord. As
The gist of it is this, not that the.
I have to submit, Mr. Shamanto. I am not shying away from arguing.
That's why I'm trying to assist you.
No, my lord, Mr. Shamanto may not be permitted to simplify it to my detriment. So,
Milord, here, Milord, what my learned friend wanted to submit before the other court also was that the authorities concerned, they were not party to the proceedings, therefore the order is not binding. This is the main point. He may make his submissions. I'll show your lordship only one document and let him make his submissions. Milord, lordship will kindly see this. That they were party to the proceedings because the matter went from the learned tribunal to the High Court to the Supreme Court. In the Supreme Court, I have brought a document which shows that they had made application. You have a copy.
Do you have a copy of this?
I've given his this thing.
I'll go by Mr. Mr. Shamanto is submitting, my lord, on facts. I will not question him, my lord. If he's submitting that. But, the point, my lord, the point is the Union of India was not represented, my lord.
What I want to say is that Tribunal, High Court, Supreme Court, there, these parties were all parties. That is what the constitution will show your lordship. Here, lordship will see in the Supreme Court, they had filed the Lieutenant Governor, Chief Secretary, Principal Secretary. Then my client, then my lord, Union of India through the Secretary, Ministry of Health, Home Secretary, Director. All of them.
No, that in every matter, if my lord sees in every WPCT filed here, my lord, Union of India as a party, but Union of India is treated as a pro forma. They are never served. They are not represented.
Petitioners hearing were parties.
No.
To this and come back, you can.
I'll send him a photo because Milord, I came. Milord, let him make his submissions.
No, my submission is, my lord, even see, Union of India is party in every case here, my lord. But there is a dichotomy in certain cases, my lord, where the Union of India and the administration, my lord, are acting as a single entity. There, my lord, the administration is only representing, my lord. But there are cases where the Union of India and the administration are acting as two separate entities, like in this case, because in this case, my lord, the delay in the direction of the Supreme Court was you have to complete the disciplinary proceedings within a particular time span. Now, that time span, my lord, because of the grade of the officer concerned, that required the consent of the president. So, because under the rules, the consent of the president was required, so it was not in the control of the administration, my lord, to actually complete it within a particular period of time, because it was in the purely in the control of the president and the Ministry of Home Affairs or the committee which acts on behalf of the president. So, my lord, in this background, my lord, where, my lord, no rule is eventually, my lord, there is no substantive right, my lord, because if, my lord, there is a direction that you complete the disciplinary proceeding within a particular period of time, and that authority is in any case not represented, my humble submission is the entire proceeding cannot be quashed on that ground, because it has not been completed within a time span. I understand, my lord, if that particular party, which is the President of India or the Union of India, was represented before the Supreme Court or before the CAT, and despite the court's direction, my lord, it was unable to complete the proceedings, certain other consequences like contempt could follow. But, my lord, to say that the entire proceeding will go or will get quashed because there has been a delay. Of course, we have submitted to the administration while it was within the power of the administration the administration filed applications for extension before the Supreme Court and sought extensions at various points in time. That is no disputing that. But during that entire period, my lord, the extensions were sought for actions that had to be carried out by the administration. Now the actions that were required to be carried out by the administration have been completed. And the administration has completed its part of the bargain or its part of the job within the time span which is given by the Supreme Court. Now, beyond that, when it is not within the province of the administration cannot force the President of India or the ministry to complete the proceedings within any particular time span. It is not within the power of the administration to do so. Nor was the ministry or the President of India before the Supreme Court or represented before the Supreme Court. So, my lord, therefore, my humble submission is that on this procedure, technical point, my lord, in fact, even in the orders extending time, the Supreme Court has recorded that this is a technical issue and it is not a question of any substantive right which is inuring to the private party because timelines have been set. In fact, that has been taken into account by the Supreme Court while extending the timeline for the administration. But my humble submission is, my lord, the cat has erred by saying that the entire proceeding, everything goes because it has not been completed within a particular time span. My lord, in any case, that was an order of the Supreme Court, my lord. If they were aggrieved by it, their remedy would have been in contempt or some other proceeding before the Supreme Court, my lord. The cat has effectively said that because you have not completed the proceeding within the timeline granted by the Supreme Court, the entire proceeding goes. Now, my lord, that in my humble submission does not follow at all, my lord, from the decisions of the Supreme Court also in the present proceedings. Lord, I'll show each of the documents and the orders because it's a voluminous brief, my lord. I'll have to show everything, my lord. If my lord wants to hear, my lord, then I can submit, my lord, subject to Mr. Shamanto's convenience also. Or it can go to the next circuit, my lord. We can do it in the next circuit.
He knows very well that I came for this matter because he's
No, I
not.
know, I'm ready. I'm ready to do the matter. I'm not shying away. I respect the fact that Mr. Shamanto is here.
But today, right? So if it spills over to next week, it will be difficult for us to deliver a judgment. Because Mr.
May I show one document, my lord? May I show one
No,
document?
I have to submit first. I have to submit first.
Yes, let him submit. Let him submit, but what I'll show just one or two documents, my lord. And if it doesn't, my lord, your lordship.
No, that cannot be that because the.
My lord,
He has to make his submission.
no, I appreciate it. My lord, your lordship will take up next week then. I'll come again if necessary.
Next circuit. If we take this up next week, it's a little longish matter. I don't think we can deliver a judgment. I mean, we don't want to carry it back to the mainland.
No, that is not.
No, it is an opportunity and learning for us, for me at least, to see Mr. Shamanto. I'll be doubly lucky if he comes again in the next circuit, my lord. Then it is better for all of us to be educated next circuit as well.
My lord, lordship will just see page 464. What? I'm used to making very short submissions, my lord. That's why I'm.
No, Mr. Chakraborty wants to go through each and every.
I will have to, my lord. The order is in his favor, so he can make short. I have to.
Nowadays, the whole concept of having a lot of books and making submissions gone.
That's gone.
Because this is the position of the matters. That's why, my lord, we are trying to make it short, and Supreme Court, your lordship knows.
Yes.
30 seconds, 1 minute is the maximum you get. Here,
No, this is thankfully not the Supreme Court, Mr. Shamanto. We are lucky that this is not the Supreme Court and this is the High Court, my lord.
Page?
page 464.
60. So, volume 3.
Acha, it is
464.
yes, my lord. Lordship just reads it. That is the main finding, my lord. And that is the short point and crux of the matter. I can argue for the whole day, but ultimately it boils down to this part only.
But since
This
he
is
wants to
the
make it such.
number, only one thing. But I have not been paid my pensionary benefits since February 2025, 2023. Let them make that payment.
No, that is being, in terms of the interim order, provisional pension is being paid.
No, it has not been paid. Let him say that he has paid provisional pension. No.
Yes, my lord, for that I have received instructions. In fact, if my lord sees,
See the last order, it says.
yes, page 404, he has been asked to give certain documents. He has not given those documents. Let him give the documents, we'll release the pension.
Pay the provisional pension and your lordship will hear it anytime.
No, that, yes, of course. Kindly see 404. In page 404, we have written to the officer, my lord. Kindly see, I am directed to say disciplinary proceeding have been concluded by MHA with a speaking order. In this regard, you are requested to provide the following documents. Information immediately for processing the pension paper with PAO2 Port Blair. So, all these, and also,
with great respect,
he has to give these things.
and that is what he said he is. I want to impose punishment. We came before the land tribunal.
Please see order dated for June.
Well, let them say what complaints they want. What complaints they want. Let them say that to him.
He has to give the documents, my lord, for his file to be processed.
Just now.
Let him submit to the authority, then the authority will process it. Or High Court's order also says so.
It is not that someone who is running or anything.
Mr. Chakraborty, deal direct release of provisional pension.
Subject to him submitting, my lord, the procedural requirements.
Subject to compliance.
Yes.
Formality. They will say, give me this order, this document, that. Am I not pensioner? Have I not been provisional pension? They can release it directly to my bank account. Let them do that, my lord.
No, this order has already been, this is the direction of the High Court also, my lord, on the last occasion.
That is because it was the last taken up. That's why. You know, at least this much I'm entitled to.
No, of course he'll get, but subject to him supply, doing the procedure, meeting the procedural requirements.
What formalities do you require to be complied with?
My lord?
What formalities are required to be complied with for grant of provisional pension? You have you have all the documents.
Everything he has got.
My lord, page 466, my lords. Kindly see. With
Yes.
respondents, kindly see para 10. Respondent shall assist the authorities concerned for implementation of interim relief granted to the respondent without prejudice to the rights and contention. So he is required to comply with this direction. He has to do the needful in terms of the High Court's order.
What is exactly the needful that he?
I can give, my lord, we will, by page 404 documents have been sought from him at page 404. I can, my lord, if my lord, either, my lord, page 404 also, my lord, it is clearly given. But if for provisional pension, my lord, then my lord may pass over, my lord, I will just take instructions and, or my lord may just give me 2 minutes. I'll ask the officer concerned.
To comply with this 404.
Because this was at that time when they wanted to impose the punishment, they wanted these documents to impose the punishment. Punishment would be
For processing the pension paper.
because of that. They're processing the pension papers after issuing the order of punishment. I couldn't do that. I couldn't violate the order of the Honorable Supreme Court, which says this is the last limit. Therefore, I didn't give it. Today, my lord, the matter is pending before my lords. I'm not running away. I cannot run away also. I'm entitled to pension. They have given me, but they have stopped it. At least without all these formalities, they can pay it to my bank account. For 2 years, I have not been given the provisional pension. How will we survive?
No, I'm just taking instructions on what documents are required. I'm just taking, just give me, why not give me 2 minutes? I'm just taking that instruction.
I'll wait. I'll wait. let that be kept in the record, which I handed over today. Let it be kept in the record as part of the order. 3 page, 2 or 3 page. No, the course title of the
2 pages.
My lord, I have sought instructions, my lord. My
Yes.
lord, because the rule is, my lord, the departmental inquiry has been concluded against him. So provisional pension is paid pending departmental inquiry. Now, because departmental is concluded, he will be given pension. To process his pension papers, the documents mentioned at page 404 are required. Let him give the documents. Then, my lord, his pension will be processed as per the rules. Kindly see page 404. We have asked for the specific documents.
that was when the punishment was to be imposed, not now.
No, this is after conclusion, after the other conclusion.
No.
Kindly see the letter. It says, kindly see page 404. Mr. Shamanto, you may also please. I am directed to say page 404 of the WPCT.
What is your difficulty in filing these photos? These are very innocuous documents.
It says copy of Aadhaar card, copy of PAN card, joint photograph, first page of passbook, joint bank account.
They don't have it.
How can you not have this?
Your PAN card.
Even if they have it, sir, when they're asking for these documents, so that we can record the subject to production of these documents in page 404, it will be granted.
Gotcha.
So that no further document is called.
Gotcha.
We have-
I'm grateful. I've understood. I'm grateful.
Copy of an application for extension of time filed by the, oh, this is an incomplete application. I cannot record this. The last page.
That is the cost title. Actually, that is what we got from the advocate on record.
I'm recording this. Third learned counsels for the parties. The matter be placed before the next available circuit bench. Paragraph. Pending disposal of the matter, comma, the petitioners shall release the provisional pension of the.
My lord, sorry, my lord, not provisional pension. His pension has to be processed. His main pension itself has to be processed because provisional.
To the decision of the repetition, the application.
Yes, but his pension will be processed, not provisional.
Now
He'll get
it's
more.
provisional bench. That's why I said pending disposal of the application.
No, my lord, my instructions are subject. Your lordship can direct, but my instructions are because the disciplinary proceedings have been concluded. So, my lord, as per the rules, he is entitled to pension, not provisional. He'll probably get more. So, he will be entitled to pension, my lord. So, his pension has to be processed.
The issue that is being agitated before this court, right?
No, but as per he's not been dismissed. So, the penalty that has been imposed on him,
2 years.
subject. So, therefore, he may get less pension than he would be entitled to if he succeeds completely. So, what we are saying is that will still be more maybe than his, I don't know, man, it could be more than his provisional pension. But the instructions are, my lord, that his pension will be processed if he gives these documents.
This application. Pending disposal of this application, let it be provisional pension. What did I say? Release provisional pension in favor of the respondent, subject to the respondent complying with the document called for by the petitioner. Vide letter dated 12th May 2023, within bracket page 404 of the application.
My lord.
Without time frame. I'll give it within 3 days to the Lieutenant Governor office or the Chief Secretary as your lordship directs.
Paragraph learned counsel for the petitioner submits, respondent submits that the documents will be made over to the authority within 3 days from date. Stop. It is expected that the authority shall start disbursing the provisional pension in favor of the respondent within 1 month.
Why 1 month, my lord? Next time circuit is coming, by that time we'll finish up. Let them pay it within 7 days.
My lord may pass order, my lord. Whatever my lord thinks appropriate, I will not bargain, my lord. As your lordship, I bow down to whatever lordship says.
From the date of receipt thereof. From the
Without,
documents.
without prejudice to the respective contentions, because that.
My lord has granted 1 month, my lord, 1 month.
2 weeks.
About 1 month.
They'll
Pension দিতে এত অসুবিধা হয়?
They'll submit within 3 days and then two weeks thereafter.
Very well.
My lord, instead of authority, let it be petitioner number 5, because my lord, they will take that benefit. They will going to submit it before the LG or CS. They don't have any authority, my lord, in this matter.
Tomorrow I'll stay back, my lord.
To make his submissions after that.
Most grateful.
Some other manner.
I'm grateful. All right.
Most grateful.
So I got the state response.
Petitioner? Yes.
The senior counsel is doing unwell today, so he seeks accommodation.
When did you come back?
Ma'am, Mondays,
Monday?
Monday.
Learned
Ma'am,
counsel,
for 1 and 2. District matters 1 and 2.
2 is a CRR.
Yes, ma'am.
So arising out of same FIR, one is for quashing of the FIR.
The other is
for
for
anticipatory.
anticipatory bail.
In another matter also, other petitioner filed that was already released. That is listed today before court number 2.
Same FIR.
Same FIR.
Your
So
lordship,
all these three will
Lordship,
list
lordship,
Monday,
yes,
right?
yes, your lord.
lordship.
Learned counsel for the petitioner seeks accommodation, let the matter appear under the same heading on 4th August. Monday is 4th, right? Please list the other matter also. It's a CRM A. Anticipatory. Please give the number.
Yes, ma'am. CRM
Apply.
A4 of 2025 and CRR 33 and
1 and 2 are here already, the other matter.
34 is coming from. Thank you, your lordship.
Next.
Item number 3, WPL 352 of 2025.
My lord, in this matter, we appear for the petitioner, my lord. What I pray, my lord, my senior is on her luck before court number 2. Let the matter be passed over for a few minutes.
Very good. Very
Lord, in this matter, Mr. Satatu Chakravarti will appear.
Which matter?
In
Third?
this item 3rd, madam.
Yes.
Instead of passover, is coming.
Yes, so I'm appearing, my lord, I'm there.
Your voice is breaking, Mr. Chakravarti.
Am I audible now, ma'am?
You are, yes.
My lord, am I audible?
Yes, you are.
I am appearing for the respondent, my lord.
Passover.
Petitioner is,
So they sought
He's asking for a short passover.
yes, is no difficulty. Whatever.
Item number 4.
In this matter, which Bhavita Raj is appearing for official respondent, your lordship, I pray for short passovers, your lordship. If you like to put number 1.
If all the matters are passed over, it
I
will
will
be
just-
difficult.
Place the brief facts, your lordship, so that my learned sister can come and thereafter she can join us.
I think it will be difficult for her.
Time lagega. I'm seeking an entry in relief, that is why.
Let it be passed over.
Okay.
Item number 5, 026 of 2025.
Yes. Petitioner?
I am for the respondent. I am for the petitioner.
Yes. For this question. Yes.
Online may not be, receipts are coming.
Online?
Led by. Personal board there are.
This relates to an arbitration proceeding?
Yes.
Yes, my lord. My lord, in this matter, one order of sole arbitrator is under challenge, where the arbitrator has given extension of time for
Again.
filing statement of claim. That is under challenge.
Yeah.
Yes, are you ready?
Online they are coming.
Millard, it's already Millard keeps it on Monday or any other date, Millard. It's already 1:15, Millard. I am Millard. Have a matter at 2, Millard. That's it.
Not only that, you please do not make your submissions from a car.
Very well, Millard. I'm very sorry, Millard. I was
Is deprecating this time and again. Are affidavits required?
No, my lord.
They want they.
It is, everything is there. So I am just opposing this, they cannot challenge this arbitrator's order during the proceeding.
The
So-
proceedings are continuing.
It is just started. They have the time extension granted by the arbitrator, learned arbitrator is under challenge. But thereafter, the statement of defense is also filed and rejoinder is also filed. And now affidavit for admission denial is also filed.
So how is this maintainable now? It's infractors, isn't it?
Let it be fixed on the
Yeah, put Monday, my lord, that since
You have
on
proceeded
the-
with the arbitral proceeding after filing this writ petition.
Statement of defense they have filed.
No, no,
But
I'm not appearing before the arbitrator, so I am not aware. Hmm. The learned counsel online, he will come
Tuesday.
Tuesday, my lord. Oblige, my lord.
Counsel for the petition accommodation of the matter appear under the same heading on Tuesday is 5th. 5th
Oblige, my
August.
lord.
Applied, my lord.
Lord,
My lord, in 5 item number, my lord, I am appearing for the petitioner, my lord.
So who sought time in 5?
Petitioner.
petitioners not.
An adjournment has been granted on your behalf, on your request.
My lord, I am appearing, my lord, let the direction of affidavit be passed if required, my lord. Because already,
You are the petitioner, you say, and the respondent doesn't want to file an affidavit.
oh yes, my lord. Then kindly fix any day, my lord.
Tuesday.
Tuesday.
Tuesday, my lord. I am grateful, my lord. I am grateful.
Item 6, CO 46 of 2025.
In terms of the earlier direction passed by this.
Sure, I'll request you to take instruction with this matter.
My lord.
Why unnecessarily take it up? I mean,
No,
it has
on,
become redundant.
on Tuesday, I will argue, my lord, if they are wrong.
See that after that. What is the use?
My lord. I will take instruction.
They have filed
I will take it.
statement, my lord.
Yes.
They are saying that there is a case pending, CO pending. By stating that, they have filed a
So
return.
this case is being shown there.
Yes. But
Come.
entire facts, statement of defense is filed. But in the covering letter, it is mentioned.
Let them come.
Oblige.
My lord, in compliance to this honorable court, I have been issued notice to the opposite
Not
parties. The receipt is there, my lord. I request my lord, next week, my lord, but it is a small point is involved.
Short.
Yes, my lord, because the there is a decree has been passed, my lord. By the passing a decree, the honorable trial court has said declaring particular second wife to be as a legally wedded wife of the deceased, who is an incumbent working under the government department. But in the second order, the trial court has said that pension benefit has to be issued in accordance with the rules. When we have processed the pension, department is not opposing the claim. Whoever it may be, whoever come, we will give the pension. We are not against anybody. When we process, that time we come to know that the first wife entry is already in the service book and PPF book has been already done. And the first wife name was at Sosan. She is a Saroj Lakra. She is the second wife. The first wife, we only sought the death certificate of the first wife because so that the pension can be released in favor of the second wife. She is not able to produce. We published in the Jharkhand where the address was given in the PPO book. So, my lord, these are the
Public service, let it appear next week.
yes, my lord. Any date as subject, my lord, please. Yes,
It's a very short one.
Yes, yes,
Can
ma'am.
be dealt with. Thursday is 7th.
yes, ma'am.
Since
I will, in the meantime, I will file the track report so that it can.
that has to come
Yes,
before
yes,
the court.
I understand.
Since service upon the opposite parties is still not complete, still not complete, comma, let the matter stand over till 7th July 2025.
Oblige me.
7th August, I'm sorry. I said June.
Item number 7, WPA 328 of 2025.
Should I for the respondent, lordship? There was a direction to file a report, lordship. I'm filing the report, lordship. I have served the copy, lord. Petitioner is a senior learned counsel of this bar. He filed this some for police protection because he was threatening or some suspected persons or follows him. For that reason, there was an interim direction. And on the basis of that direction, the police department already executed and secured some police personnel for coming, going to the court and the located house of the petitioner. The report is there that we have complied. And the petition is now at mainland for treatment also.
Yes, please.
Can be disposed, can be disposed of
Actually,
because
can be
already.
disposed of,
Yes.
but you've seen the report.
Yes.
Tomorrow. Tomorrow is a working day. Come back tomorrow. Yes,
Tomorrow,
very well. A report submitted by the a respondent is taken on, respondents is taken on record. Paragraph on prayer of the petitioner. Let the matter appear under the same heading on 4th.
Yes.
Next.
Item number 8.
Otherwise, she'll go there.
Oh, you are in which matter?
Item number 4. You.
4th. Oh, the passed over matter. Yes.
Fact number 4, WPS 5/125.
Here the petitioner is challenging to impugn order marked by Tehsildar, whereby he has directed the petitioner to demolish the compound wall which is existing since 1980. So now the entire process has been done by the Tehsildar without giving any opportunity. Neither have been served with any notice, nor I was allowed to participate in the proceeding.
Where is the order in
The order impugned appears at page 16, P1. In this order itself, it will be clear, Your Lordship, no opportunity of hearing was given.
16, 1/6.
1/6.
16 is part of your application. That's not the order in given.
That very bulky which has been given.
It's a wrong file was given. 16, right?
16.
Yes, this is a direct order for vacating. No notice was issued prior to this.
Notice? No, I didn't participate in the proceedings. Direct evictions. And Your Lordship may kindly see the adamant.
But in all the cases, I am finding that this is being done. A direct 104 eviction notice is issued. Is there no provision for hearing the incumbent?
There is a provision, my
Before
lord.
you ask him to vacate.
No, actually, in the order, my lord, there's no mention that they have sent notice and all.
Did you
So-
serve a notice and
Yes,
did you
ma'am.
give an opportunity of hearing?
Very sure.
Please show me the notices.
My lord, let this matter be fixed on Monday, my lord.
That's okay.
I'll take
The
it.
demolition will take place on the 3rd.
Yes, come back tomorrow.
Tomorrow is Saturday.
Tomorrow is a working day.
Working day.
You can come back here tomorrow. I would like to see the notices.
My lord.
Then I can pass an order. You need to show that notice was served upon the petitioner and the petitioner was granted an opportunity. Issuance of notice will not help. Let me be clear. Yes, should have been received by the petitioner. The petitioner is aggrieved by the order passed by the Tehsildar Sri Vijayapuram on 25th. This is 25th
July.
July 2025, directing him to vacate/remove the unauthorized occupation over Government Road on or before 3rd August 2025. Paragraph, learned counsel for the petitioner submits that such order was issued without service of notice upon the petitioner and without granting him an opportunity of hearing. Paragraph, per contra, comma, learned counsel for the respondent submits.
My lord, I have for
Submits.
the official respondents, my lord, the private respondent is also there.
And served, because upon whose complaint the
Where is the service?
service fine.
Because upon her complaint only the proceeding was initiated, my lord.
Where is the service? Where is the traffic?
The track record is not there.
This is issuance. This is not service.
It is issues.
You have to serve and come. Can you get the track report by tomorrow?
I'll try it. Because tomorrow is not working day for us here. So,
For the High Court, it is working.
But for
for the first
officers.
time, Saturday we'll work here.
On earlier occasions, maybe the circuit was not there. That's why you're all
Circuit
aware.
was there and we have.
This has happened earlier also. We have worked on Saturdays.
Yes.
It's a compensatory working day for us.
Hmm.
I'll not insist. If you can come tomorrow, it's fine because it's for your benefit that I
I come definitely.
Yes, and please have the track report with you because otherwise I'll not be able to pass an order. You can take this back. Without the track report, this will not help. You'll need the postal receipt number also. Hmm? Oh, this is, oh, you have a copy of the postal receipt?
Yes, I have.
First line affidavit of service filed by the petitioner is taken on record. Service upon the respondent is not complete. Then the remaining part. Learned counsel, yes. That notice was served upon the petitioner, official respondent, so learned counsel for the official respondent submits. That notice was served upon the petitioner prior to passing of the order impugned. Learned counsel seeks to produce copy of the said notice on the adjourned date. Paragraph, by consent of the parties, let the matter appear on tomorrow's date, 2nd August 2020. Next.
Number 8, WPS 334
Served.
I'm ready to serve. Because I have signed up to
Right.
on the restaurant number 1, the way to serve the restaurant number 2, but I'm ready to serve.
You ought to have served by now, isn't there? Was a direction for service.
Yes, also because they sponsor for the responder is our two.
That is the first respondent, right? You have not served the second respondent, you say. Have you served the second respondent?
No, I served upon the respondent number 1.
Yes, so please serve respondent number 2 and come back. Tuesday
Yes,
or Wednesday, then come back on Wednesday. Yes. Since service upon the second respondent is not complete, comma, let the matter stand over till 6th August. Next.
Item number 9, WPS 344
Both the petition. This is an application for grant of electric connection.
Have you served?
I have served all the respondents.
Who is appearing for the respondents?
Mr. Yassi is appearing for.
Yes, but where is he? He sought time on the earlier official. Let it appear on Monday. Will you inform him? Yes, let it appear on Monday. Please inform him. None appears for the respondents. Stop, no accommodation is sought. Paragraph, let the matter appear under the same heading on 4th August 2025.
I appear in person for the private respondent.
No, I'm appearing for the official respondents.
My lord, may kindly see the previous order. This is happening since from the day when the writ was filed, my lord. For one or the other reason, they pray for time and it is allowed to them.
Not the.
Right, that here. Yes, we just
Several adjournments have been taken by you. Please make your submission today.
My senior is for the petition.
Yes.
Some difficulties may not fix on.
What is that? What difficulty? Personal difficulty of your senior? When will you come back? The court cannot stand in the way of personal difficulty
Kindly see the last order passed by.
Adjournments have been taken by.
I will.
Order on the last occasion, my lord, may kindly see. Civil suit is pending between the private respondent and petitioner. Obtain a stay or status quo order over there. Till date, they have not filed the written statement. They are dragging the matter only because writ petition is pending.
Dispute is, there are two private parties. The petitioner has approached being a temple committee, the petitioner being an adjacent plot order of the respondent. She approached initially at 2001, saying that in my passage, certain construction has been going on. And stay order was issued in 2001. Subsequently, thereafter, they also filed, the respondent also filed a complaint. RC case registered, inquired, and under 104 order has been passed for removal of the abstraction, which is in favor
You
of
say it's private property.
both are private properties.
So why 104?
So being a Tahsildar, and they made a complaint before the Tahsildar saying the Tahsildar should take action in terms of the Andaman Nicobar land revenue and land reform rules.
104 is also in respect of private properties.
Yes, my lord, because
Or
it
is
is
it government land?
no
Service.
private. If there is a government path passage, then 104 will apply. If it is found to be
Yes.
government.
It's not a government.
Do
So
you
that-
just 104?
That's what we have done the proceedings from 2001, 2002, 2003, 2004. This court has told, because of 2001, it was quite old document. So they are harping upon the honorable court that 2001 proceeding has to be continued. Why that proceeding is not continued? So this court has said you trace out the records
How was the proceeding initiated? That is my first question.
based on the.
It is admittedly private land. Where is the public element for a writ
But
petition?
they say it is a passage, so notified path has been occupied. So they're being of Tahsildar to
So
clear
the
the.
path belongs
Path-
to the other
Absolutely, it belongs to.
property. It's not government land.
No, path belongs to the government land. It's a set apart path. So everybody belongs to the general public. So path is to be belongs to the general public, not a particular individual right over that particular
So
public.
the civil suit needs to be disposed of first.
That status quo is already been
There
there.
should be a declaration to the effect that that path belongs to the government and not to either of the parties, right?
Kindly see, I will close in my affidavit of position, page number 16, the suit was
Since
filed.
it's not ready, let us not spend more time on this. Please come back. When will you come back? Tuesday? Please be ready, sir. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 5th July, 5th August 2025. Next.
Item number 11, is WPA 992 of 2023.
Private respondent.
I am for the official respondent.
I have been granting adjournments to you on several occasions. 5. Tomorrow. Yes?
Yes, sir.
Why not tomorrow? Short issue?
My lord. Short one.
It's a short issue.
Where
They
is
encroached upon my land, and the entire proceeding before all the authorities concluded. This writ petition is pending.
Where is the public element? Encroachment on private land.
Yes, they have made a.
Tahsildar is empowered under regulation 161 to pass an order if it is found within 2 years it is encroached by the
Private land.
adverse party.
Yes, sir.
Private land.
Regulation. 161.
161.
Yes, there is a provision.
It will not be in a civil suit.
No,
Yes, it-
Tahsildar
if it is within-
If it is
within 1 year.
Continue the summary procedure and they will pass.
and restore the position, that is the
161.
161.
So summary procedure.
Yes.
So in case of private property also this is done.
Yes.
They file an appeal, appellate authority, second appellate authority, all fail. But this petition is filed and 9.88 square meter land they encroached my land, which is found to be occupied within 2 years. And Tahsildar pass an order.
Monday.
Oblige, my lord.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 4th August 2025.
Lord, the substituted parties, respondents have been served. My lord, I've been sent with the WhatsApp. I'm not able to file the affidavit service today. It has
You are the
come.
petitioner.
I'm the petitioner. As my lord has also told me to take clarification whether the department is going to settle as is the MSAT claim. So my lord, there are two aspects. One is that he has got a compensation under the Compensation Act. The department voluntarily paid it. subsequently, when motor accident claim as tribunal he has approached, so there are two compensation he has already got, madam. So that is the only dispute they have.
Let me send it for mediation. MSCT can be done in mediation. And a mediation week is also good.
No, my lord, the only problem, I'm sorry to interrupt, the only problem over here, the section itself says that the family of the deceased person will only get one compensation, either under the workman's compensation or under the, my lord, motor accidental compensation. They got both of the compensation. We have judgment, my lord, upon that.
Let this be decided by the mediator.
My mediator could not be, my lord, able to decide, my lord, this question, my lord.
Why can't the mediator decide this question?
Because they have a purely, my lord, legal question, my lord, whether two compensation can be given when section itself mentions that. The MSCT court totally ignored that section, my lord. I am very sorry, my lord, I have to, my lord, disagree with your lordship view, but my lord, this is the, my lord, seen in this the fact of this matter, my lord. That is the only, my lord, point on which we have challenged this order, my lord.
Serve and come back, let us see.
Yes, yes.
Since service upon the substituted substituted private respondents is not complete, comma, let the matter stand over till 6th August.
Great.
Next.
Item number 13.
My lord, this is that matter where, my lord, yesterday my lord had indicated, my lord, that we have to show that appeal has in fact been filed against the order passed in the similar matter. So Mr. Kumar has got the detail. He'll just hand over, my lord.
Yes. Give the number whether the appeal has been filed.
Have you got the number, madam?
Appeal was filed way back in April, my lord. I think the registry was, there was some delay.
Similar issue. 14 April. Number
Finding it like that.
Number आज मिला 14 July हम लोग पाएंगे.
Finally, see date of filing is today's date.
No, Lord, we have filed it on 14 July. The number was given today. Milord, will call for the records.
Filing date 1st August, registration 1st August.
We are getting every time, we are getting same date.
After the direction given yesterday, it was filed today.
No, Milord, the record will see, Milord, it is filed on 14 July. Milord, will call for the records.
The document that it was filed on 14 July.
Filed in 14 July. Milord will kindly, Milord, just check the numbers, as Milord told us to procure the number.
No, my lord, I have also, my lord, I was aware that it's filed earlier. My lord can call for the records from the registry. It was not numbered. What happens is only when it is numbered, it reflects in the case status, my lord. That must be the reason. It was filed earlier, my lord. It can be ascertained from the registrar or from the filing section.
It's not that you file in July and you get.
14 July, we are filing. No, I personally checked the records. Yesterday, I went to the registry and verified. That's why.
July also. The registry except on 14 July, the filing.
That is
will be 14 July only.
Yes.
And date may be given, maybe number, I don't know what they are saying.
When it is generated, when I asked, when they said it will be generated, then only the number will be given. I said the matter has been filed. It may not be called for the records.
The memo of appeal.
Copies I don't have, Lord. Password may be given. I give the memo of copy of appeal. Password.
The date should be there also.
Not the record, it will be sent in the registry.
This was 1st August.
No, Lord, we have filed 14 July. I personally checked it.
My lord, Mr. Kumar has himself inspected the records yesterday. He has himself personally inspected the records, my lord. I trust him, my lord. If he's saying so, my lord, there's no question.
There's no question of a trust and mistrust, but there is no reflection in this document.
Lord,
my lord, he can ask the department to give him some kind of proof that it of filing. I don't know, but if it can be obtained, my lord.
Registry, my lord, when it can be filed, it will be.
Let it be kept on Monday, my lord.
Tomorrow.
Yes, yes.
Okay, my lord. He'll get it tomorrow.
Learned counsel for the respondent submits that an appeal pertaining to a similar issue as in the present application was filed on 14 July, you said?
Yes,
on 14 July 2025 and is pending. The documents produced on behalf of the respondent indicates that such appeal was filed and registered today, comma, that is, comma, on 1st August 2025. Paragraph, the department is directed to submit a report tomorrow with regard to the date of filing / registration of the appeal being number 42 of 2025. Appeals being number 42 and 42 of 2025 and 43 of 2025. Paragraph, let the matter appear under the same heading tomorrow, comma, that is, comma, on 2nd August 2020. Next. Please send this to the department immediately after I sign.
Item number 14, WPS 3/2024, with another 15, WPS 3.
Your Lordship, item number 14 and 15 are similar matter, Your Lordship. In item number 15, Your Lordship, one of the petitioners wants to withdraw.
Want to withdraw her case.
Files,
We have filed an application to that. Where it was found that before that had been able to.
you are not seeking any further liberty, right? You are only withdrawing. Can. You filed the can today? It does not come to. Does not come. This is the second letter. 314. This is 15, yes. 3 wants to withdraw. Srimati Gopala Jay Lakshmi, she wants to withdraw. But the can has to be on record. Will you come back tomorrow? Please get the can by tomorrow. Can 1? Can 1 of 2025 is not in the file. The department is directed to put up the application along with the file tomorrow. Paragraph, let the matter appear under the same heading tomorrow, comma, that is, comma, on 2nd August 2025.
Well,
Next.
Item number 17.
16.
16 same, Your Lordship.
16 and this 16 and 13 are similar, madam.
where my lord has directed the registrar tomorrow to submit it.
Item number 17.
Your Lordship, I am for the petition.
Lord, here I seek till Wednesday, my lord. This has already been vetted by the Lord. I filed the reply on Wednesday.
Kindly see, Your Lordship, the order to file the affidavit in opposition. I think it is 1st October 2020.
You are the petitioner, right?
Yes, Your Lordship. They have to give 3 months salary to me, to which I have worked. For that, Your Lordship, from October to now July has come, they have not filed the reply.
But I've been told, my lord, we filed it in Wednesday, positively.
Wednesday will take us to almost the end of the circuit.
My lord,
File earlier.
Yes, Your Lordship, let it be disposed of in this circuit. How much the petitioner should suffer?
What is the ground for withholding this salary? Any proceeding pending?
Nothing. No, it's order 1st October 2024, Your Lordship has already observed in the order also. By a letter dated 1st March 2023, the petitioner was engaged as an ex-pilot by the responded administration. This fact is also confirmed in the order number dated 21st March 2023, issued by the administration. Significantly, the petitioner claims unpaid salary for the period between this and this. In view of the prayer of the let this matter appear on 4th October. Then after this, they have been taking that.
we have to declare in the affidavit why this payment has not been released. So there's a matter of last, my lord, I'm seeking still Wednesday, it will be fixed, my lord. It will be a small point.
Yes,
It can be decided.
Take instructions.
Lord, I told it will be reached.
Why do you require an opposition in this matter?
My lord, opposition has been drafted in this matter. We shall file it in this week, my lord.
Monday, not this week.
My lord,
I'll take
Very
up.
well, my lord, we shall file it on Monday, or my lord, we have one more issue involved in this matter, that is, my lord, maintainability issue, because my lord, cat is there, my lord, they should, my lord, first go in cat, my lord.
Yes, what
There is a judgment of this court on of division bench, my lord, we shall lie upon that judgment, my lord.
Can the tribunal deal with this? He was,
No, they have not gone to the tribunal, my lord, that is the my lord, question.
See, sir, it's there. The tribunal cannot do it.
he was an ex-pilot. Can the tribunal deal with this?
My lord, deal with this, my lord, because tribunal has ample power under section 14 of the Central Administrative Tribunal rules, my lord. Act, my lord, sorry. We shall, my lord, show at the time of the argument, my lord, we shall rely upon.
Act. Central Administration. Yes, you're referring to 40.
Section 14(1)(4), my lord.
Yes, it is any all India service. So he is included.
Any, my lord, it's a very wide power, my lord, and there is the judgment of Venkatesh Kumar Singh, my lord.
Here,
My lord, my lord, my lord.
Notified leadership, this is Port Management Board, and this particular person is working as a seaman. That is a pilot, ex-pilot in the sea service.
Yes.
That is not included leadership. I will place the judgment. Up to the point. If they are taking the point of maintainability after so many months, I will take that particular, I will place the judgment.
So it's not all India services?
No, your lordship. It's not all India service. He has been engaged only for certain duration on contractual basis. As an ex-pilot to fly the vessel.
Yes,
It
a
is not all
service
India
includes
service.
a permanent service as well as a contractual
But
service.
your lordship, this particular service is not included, your lordship. I will place it.
Monday?
Yes, your lordship. I'll place.
Monday, please have an advance copy.
My lord, great.
Learned Counsel correspondence seeks further extension of time to use the affidavit in opposition as sought. Paragraph. As a last chance, the prayer is allowed. Paragraph. Let the matter appear under the same heading on 4th August 2025. Next. Served.
Sir, I am appearing in behalf of the added respondents.
Yes, what is the matter about? How can all the matters come on Monday?
Coordinators already decided the matter because
There's three similar ones.
present matter cannot be taken up because the visa order has been passed by airport, they know the land to pay them. But the subsequent records have been brought on record, which shows that this land belongs to, it's a government revenue land. So the coordinate bench to decide the list involved is present appeal, asked us to add deputy commissioner as well present.
So they have added.
So you've added, yes. So now the matter is ready for hearing.
Yes. I will do that on Monday. Pretty sure.
A report was also called for
Yes, yes.
from the deputy commissioner. Please see the order dated July 4th. Deputy Commissioner and Tehsildar, you are appearing for the Tehsildar?
No, my lord, I am appearing on behalf of Deputy Commissioner as well as the Tehsildar.
You are the eviction officer, right? Report was called for from Deputy Commissioner and Tehsildar. With regard to the status of the land, please see this order.
Copy was served upon us on 29th July.
So that.
Please see this order, July 4th, 2025.
Ma'am.
And please comply with this order on the next day, Tuesday.
Tuesday, ma'am.
The learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 5th August.
Obliged.
Item number 19, Blair 2025.
It's an application for quashing. Application, my lord, this needs to extend the order. We were waiting for the state.
My lord, he has requested me to keep this matter on Monday, my lord.
How many matters can be heard on Monday? All the matters are being shifted. Is it a short matter? No. Next circuit.
It's a very interesting point of law. There's an ancient law in these islands that you cannot take videos and pictures of any of the indigenous tribes, 6 indigenous tribes. Now, in this particular case, the petitioner is a documentary filmmaker who works for the government of India. Sometime back in the 1980s, there was a lieutenant governor here who wanted to see the Java. So he went with his BDC and all of his retinue. And over there was a Doordarshan filmmaker, an authorized filmmaker, who took videos and pictures of the lieutenant governor, police officers, staff, how it happens with the job. Now that footage was aired on national television. It was never an offense at that time. Now in the meantime, the law underwent an evolution. So you have something called the PACT regulation, Andaman and Nicobar Protection of Aboriginal Tribes Regulation. This was originally in the 1800s, then it has gone through amendments. Now the latest one comes in 2012, and it says you cannot use pictures or videos of the tribes for a commercial purpose. Now this has got blurred with the law that you can't take pictures and videos. Now this gentleman had made a documentary in which he was given that footage from Doordarshan because that was Government of India, Prasar Bharati, and he made the documentary which was then uploaded in Delhi. Now, in the meantime, National Commission for Scheduled Tribes suddenly receives an anonymous complaint saying Jarwa videos are there on YouTube. The Lordship may know in 2012 there was one incident where some tourists had gone, they made the Jarwa women dance, took videos. This was a big issue. Now that was taken up suo moto by National Commission for Scheduled Tribes. Although Jarwa are not a scheduled tribe, and therefore the National Commission has no jurisdiction of the matter. They directed the administration to take steps. The administration told the police to lodge an FIR. Now, in a series of knee-jerk reactions where no one really understood the factual situation, an FIR was registered. I am not responsible for that Jarwa dancing video, but they took a report and they found 99 videos relating to the Jarwa on the internet, some of which are uploaded by Rajya Sabha, some are by Discovery, National Geographic, and the police had prosecuted everyone. What they found was that all these videos and all these uploads are not really offences for absolutely inexplicable reasons admitted by them in the charge sheet. They filed a charge sheet only against me. And absolutely inexplicable, they admit that I'm a documentary maker, that I have no commercial interest, I'm working for the government. They admit everything and then they file a charge. I don't will see Justice Joychand Gupta's order. His Lordship has written a very detailed order because His Lordship found a clear prima facie case. And in fact, I have also raised a constitutional argument, which is a little unusual in a quashing application. In terms of Article 14, that's why my lord will find everything is kept under seal cover. I have taken out from newspapers and from the public domain in these islands, including the government newspapers, a host of pictures of the tribes. Now, the government publishes photographs. There are people who are from the Election Commission, from the DC office, from the police who are publishing photographs. Now, what is an offense has to be dealt with in context of the law. They have no commercial interest, neither do I. They work for the government, indirectly, so do I. Now, there cannot be double standards in the law. And the third and most
You are the
interesting
defendant
argument-
or plaintiff?
No, my lord, on behalf of the state, my lord, on behalf of Sumit Kankar.
The third and most interesting argument is an argument which will be based in 187, 188 CRPC jurisdiction. If I was sitting at Delhi
and I uploaded the video at Delhi. Where was the offense committed, given that it was uploaded on YouTube, which has servers in California? No part of the offense took place at Indigenous. And more importantly, if there was an offense, the offense is of the person who made the video, not the person who uploaded the video. In which case, we are now to prosecute people who did this in 1980. But in 1980, this wasn't an offense. So Article 20, Clause 1 comes to the front.
Have you served the de facto complainant?
So, print of services on record. But they have not appeared. None of them have appeared. In all honesty, I must say the de facto complaint has probably been transferred out from here. That was my instruction. We have served on the office. The Tribal Welfare Department.
Was this complaint in his official capacity or in his personal capacity?
So official capacity will be, that is why the designation remains. So we have served it on the office. In any event, my lord, as I understand informally, Mr. Karmakar will appear for both of them because he represents the state and they are also part of the state because they come under the administration.
Yes, yes.
It's a very interesting matter, but this would take some time.
I wish I could take up this week. Next week is difficult.
I have some matters in Delhi. I would not be here Monday and Tuesday, but you can keep it on Wednesday or Thursday then.
Then how do I complete? I need to pass
That is why I said it.
deliver a judgment. Circuit
It's a
by
very
consent.
interesting point of law.
Next up.
Be something.
I know what all you've submitted. It really sounds
So that's
interesting.
an asset.
I would have loved to deal with it, but then different. I'll extend the interim order. Oh, it's already 31st August. Yes. So let me. I'll shift it by consent of both of you. No. Yes, by consent of the parties, the matter be placed before the next available circuit.
If
I'm like. One passed over matter.
Possible matter, item number 3, WPA 3/125.
This is a case where the authorities, the petitioner is working as a junior engineer in the department. Now the petitioner wanted to go for further education. He wanted to complete his masters. So he had submitted an application seeking study. This study leave application was pending before the authority. That authority has forwarded to the administration for approval. In the meantime, as there should not be any problem, the authorities process the case. The authorities ask the petitioner that you execute a bond, you executed a bond. Thereafter, the authorities ask the petitioner that you hand over the charges to another person and handing over, taking over charges was done. Everything got completed, but the study leave application that was pending. Petitioner went there for the study, for studying his master's degree. He completed it, master's degree. In between, a show cause notice was issued to him that this is unauthorized leave.
Study leave was not granted to him.
Not granted. I'm also saying not granted. It was pending before the administration. So, Your Lordship, the entire thing went on like that. Then show cause notice was issued. Thereafter, I have been to this honorable court twice. Now, Your Lordship may kindly see the of this honorable. Page. One 96. The present writ petition has been filed inter alia challenging the order dated 24/1/2025 passed by the Secretary Shri Vijayapuram Municipal Council rejecting the petitioner's representation for dropping the charges leveled against the petitioner. In order to appreciate the controversy between the parties, it is necessary to note down the facts leading to the filing of the present writ petition. The petitioner has been serving as a junior engineer under Shri Vijayapuram Municipal Council. A disciplinary proceeding has been initiated against the petitioner for alleged contravention of Rule 3, 1I, II, and IIL of the Central Civil Services Conduct Rules 1964, read with Rules 27 of the Andaman and Nicobar Islands Municipal Service Rules 2008. From the article of charges leveled against the petition, it would transpire that the petitioner had proceeded to bail on medical leave with an application dated 25/10/2021, but he did not submit original copy of the medical certificate. He proceeded on leave for a period of 2 years with effect without approval of competent authority and remained absent from duty unauthorized. From the aforesaid article of charge, it would also transpire that the petitioner applied for study leave for a period of year on 12th March 2021 to pursue Masters in Engineering, Master of Technology in session 2021, which application incidentally, along with requisite documents, is under process of the session for obtaining approval of the environment. According to the source which the petitioner perused, is very much essential for certificate office service. According to the there are valid reasons for him to seek leave, and the discipline proceeding had been initiated only to grant it. A representation was also made by the petitioner for dropping the charges of regularization of leave, and same had been pending consideration at the end of Secretary for the Municipal Council since November 2023. It is in fact noted about the petitioner had approached this court. By an order at 11th December 2024, a coordinate bench of this honorable court, taking note of the plight of the petitioner and without entering into the merits of the disciplinary proceeding pending against the petitioner, had disposed of the same by directing the Secretary of the Portland Municipal Council to consider the request of the petitioner for dropping the charges, with a further direction that if it appears to the authorities that there is any requirement of proceeding with the disciplinary proceeding after consideration of this representation, then steps may be taken in accordance with this. Such decision was directed to be taken at the earliest positively within a period of 6 weeks from the communication of such order. The court would reveal the Secretary Shri Vijayapura Municipal Council, by an order dated this, has decided on the petitioner's representation. A perusal of the aforesaid order would reveal that the Secretary has stamped it mechanically and the representation has been disposed of without application of fine. Challenging the above order, the petition has been filed. When the matter was taken up for consideration by this court on this, it was submitted on behalf of the petitioner that the application of the petitioner for study leave still pending approval. Having regard thereto and noting the spirit of the order passed by the coordinate bench of this court, by order dated this, had directed the respondents to take appropriate instruction. Today, Mr. Kumar, learned advocate representing the respondents, would submit that the petitioner's application for study leave is still pending with the authority. Having heard the learned advocates appearing for the respective parties and having considered the materials on report, I am of the view that the Secretary, Mr. Vijayapura Municipal Council, ought to have taken into consideration the pendency of the petitioner's application for study leave. In ordinary course, the respondents ought to have disposed of the application for study leave prior to taking a decision for initiating any discipline proceedings. It has not been done. And although in the witness of things, it could have been prudent to await the disposal of the application for study leave. However, since the aforesaid aspect has not been considered by the Secretary, Shri Vijayapuram Municipal Council, I am of the view that matter needs to be remanded back to the Secretary, Shri Vijayapuram Municipal Council, for a fresh decision as regards reconsideration of the representation of the petitioner and the issue with regard to the pendency of petitioner's application for study leave. The Secretary Vijayapuram Municipal must take a decision in this matter by passing a reasoned order in the period of 8 weeks. 8 weeks from the date of communication of result by affording opportunity of hearing to the petitioner, he may either choose to dispose of the same or await disposal of the application for study leave. Needless to note that after consideration of the petitioner's representation in the mode and manner as provided herein, and upon considering the petitioner's application for study leave, if the respondents are of the view that there is any further requirement to proceed with the discipline proceeding, then necessary steps will be taken in accordance with law. In the alternative, the response of the view that the approval can be granted to the application for study leave, then as an absolute corollary thereof, the discipline proceeding shall stand dropped. Since no affidavit, my lordship, it's a clear-cut order, your lordship, by the honorable court, that first of all, you have to take into consideration with regard to the application of study leave. Now, your lordship may kindly come to the order of the 200. Page number 208. Yes. It starts from 208. All these, whatever has taken place, whereas your lordship it is written. Now, your lordship may kindly come to page number 216, paragraph 3. Yes. Even after issuance of memos and chauffeurs notice, the petitioner continued with the course and did not report back to the place of posting, despite knowing the fact that he had no leave at his credit, and his application for study leave has been disposed of. When, your lordship? How and when? Because till the hearing before the Honorable High Court in the last occasion, the application was pending. It has been submitted by the council that application is pending. Then when it was disposed of? Nobody knows. The Honorable High Court was very categorically observed and ordered that the application for study leave is to be looked into first. If the study leave is allowed, there's no question of any disciplinary proceeding against the applicant. If you're rejecting the study leave, then the question will come. So when the study leave that up to, Your Lordship, is 18th March 2025, the application was pending. And now the order is passed on 23rd May. Within 2 months, the study leave application has been disposed of without even informing me that what is the fate of that study
No,
leave
not
application.
only that, this order says it was disposed of even earlier to this order.
Yes, Your Court. It appears to be like that. I am praying for stay of this order. Because now the secretary has written a letter to the, has passed the order that major penalty proceeding should be initiated against me. If Your Lordship, I'm not going into the merits of the matter. Otherwise, Your Lordship, if Your Lordship wants, I will show that when I filed the application for study leave, how the authorities proceeded with it. They have even written to the administration that this course is very much necessary for the service of the petitioner, for the department also. They have recommended my case. And they made me to execute the bond. They made me to hand over the charge. Otherwise, what the record? They should have rejected my case. Unless until approval is there, nothing will continue with your service. I could have done it. There was no question of handing over and taking over of charge also. And now this is the thing.
Let us hear the response.
My lord, my lord will see it's a very detailed order, my lord. We can file our affidavit, my lord. And my lord, this direction is from 23rd of May 25. There is a direction to expedite inquiry and submit a report. But they have not stated whether what steps have been taken. So it is, my lord, we'll file, my lord may grant us time to file affidavit. I don't think, my lord, anything is happening as of, unless the petitioners, unless Anjali ma'am has some information. Because I don't think there anything is happening as of now. So we can file our affidavit. My lord may grant us 3 weeks. We'll file our affidavit. And my lord, matter can be fixed for hearing after that.
What has to be stated?
Because my lord, disciplinary proceeding has not even been initiated. So therefore, today, my lord, it is premature. Eventually, even if technically, academically speaking, inquiry is initiated, he will get full opportunity. It is not, there is no prejudice to him if an inquiry is initiated. Because the fact-finding inquiry officer is only a fact-finding authority, my lord. So what will he do? He will give him no notice, then he'll submit his written response, evidence will be led. So, my lord, there is no prejudice at all to the petitioner, but my lord, we'll file a response, my lord, may grant us stay.
The stay is required at least. I've seen the order. There is already a proceeding initiated against you.
No, Your Lordship, that proceeding, Your Lordship, they have stalled the proceeding and they have said that
a modified charge memorandum is has been supplied to you already.
No, not supplied till now. Had it been done, Your Lordship, I would have challenged that order. It has not been supplied.
So therefore, nothing has been done. So it supports that means nothing has been done.
Wait, Your Lordship, for the charge sheet and then have to come.
Please come back with your affidavit in 2 weeks' time.
No difficulty, no difficulty. Yes, yes.
I don't think the stay is required at this
time. Your Lordship, my interim order, Your Lordship, let there be observation. In 2 weeks, it is not filed. I will be entitled to press for my interim. Let there be.
No, no.
What every time? No. What is this, Your Lordship?
No, I'm only making my submission.
What do you want? Answer. Yes.
Is there a prayer for interim order in your application? Stay of disciplinary inquiry, that is.
This is the order. So on the basis of the discipline, they are going to initiate.
Has not.
They have
an inquiry which has not been initiated at all. How can that be stayed?
Your Lordship, on the basis of this order, they are going to issue the charges.
Yes, so May to August, they have not. So let it be 2 weeks and 1 week, you can come back. I'm not rejecting your prayer. I'm not dealing with it at all.
I'm only praying, Your Lordship. Otherwise, the court will consider, subsequent court will consider that it is deemed to have been rejected.
No, I'm not recording that you're mentioning it. I'm not recording anything. I'm just giving a direction for exchange of affidavits. Come back. It will not be to your prejudice. Let me detail.
You know, so these people, I know, your lordship, they are taking time only
She
for
can
that
agree,
purpose.
she can file like.
No, I'm,
You can even.
no, we are here, my lord. If I am there, definitely I will not, I will remember this point.
My entire case is based upon that particular paragraph. If they are able to show that study leave has already been rejected, my writ petition may be dismissed.
No, we will
Let
file
them
the reply by detail because not the.
No detail is required. My argument is only that.
But it is a big.
For them,
We'll file our affidavit, we'll file.
Rejection order can't be shown on
Yeah.
Monday. This is the order which on
the court will not accept a rejection order like that, madam. It has to be by way of an affidavit. Let them come.
I am
Let them
entitled
come.
to let us stay, your lordship.
The heard learned counsels for the parties. The petitioner is aggrieved by the order passed by the Secretary, SVPMC on 23rd May 2025. Directing initiation of disciplinary proceedings against the petitioner under Rule 10 of the Andaman and Nicobar Municipal Service within bracket classification, control and appeal, bracket closed, rules, 2008, read with Rule 14 of the CCS within bracket CCA, rules 1965. The respondents seek to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks from date. Affidavit in reply, if any, be filed within a week thereafter. The matter be placed before the next available circuit bench.
Liberty may be given, your lordship. Liberty may be given.
On one line, liberty is granted to the petitioner to seek stay of the order impugned, if occasion so arises.
Yes.